share with you briefly some facts of his life. He graduated with the degree of AB Economics and Math and Bachelor of Laws degree at San Beda College. He is a former labor arbiter of the National Labor Relations Commission, NCR, a professor of law, pre-bar reviewer, and MCLE lecturer. He is also the president and executive director of the Center for Law Advocacy and Specialized Studies. He was also the former assistant secretary of the Department of Environment and Natural Resources. He is also the former POEA Director for Licensing and the past president for the National Association of Labor Arbiters Incorporated. Ladies and gentlemen, it is with great pride that I introduce to you Professor Oswald B. Lorenzo.
Thank you. Okay, let's all stand for a 5-minute prayer for the Almighty and for Allah. Okay, good afternoon. I am equally privileged to be a lecturer in one of the biggest, if not the biggest, review center in the country. This is the Recollectos Review Center. Okay. We are here to tackle labor law this afternoon, and we are no longer counting weeks, we are no longer counting days, but we are counting minutes and seconds towards the first Sunday of September. Okay. That will be the D-Day. You know, when you go to De La Salle on these 4 Sundays, you are not only marching with history, because you are all history in the making. Okay. We will attempt in the 16 hours of lecture to explain labor law in a conceptual approach, because I know that all of you have already read the provisions, the materials, but my task, aside from the substantive portions of labor law, I will attempt to aid you in how to answer practical questions in the afternoon of September 2010 bar exams. Preliminarily, I would advise you not to get 100 in labor law. Get only 99.9. Why? Because in conscience, you may be the cause of the collapse of 2 examiners in labor simultaneously and put under sedation immediately. So get only 99.9. Okay. So let's start. For those who are not here, I'll be writing first the materials on the board. If there is a constitutional provision that I would like you to read once more, it is Section 3 of Article 13 of the 1987 Constitution. Section 3, Article 13. Okay. Why am I saying so? This is an important provision. Because in the last 3 bar examinations, questions were asked in number 1, A or B, from Section 3, Article 13. So let's review the first question 3 bar exams ago. What do you understand by the principle of codetermination? Okay, you do not find this material in any books of authors, but you can find the concept of codetermination in the minutes of the proceedings of the 1986 Constitutional Commission. So in a question propounded by former Commissioner Felicitas Aquino, now Mrs. Joker Arroyo, asking Vic Foss, the compiler of your Law Gazette, asked, is this co-determination the same as the co-determination in Europe and Japan? Okay, the answer was not, because in those countries, the right to co-determination means that the union president or the association head sits in the corporate board of those entities abroad and determines, he is part of the determination of the inner workings of the corporation. In other words, he's part also of management. But in answer to that question, the right to co-determination simply means participation of the workers and employees to policy and decision making, excepting herefrom the exercise of management prerogative. Exercise of management prerogative. Then came the bar examination 2 years ago. And the question was this: what is the extent of the workers' right to participate in policy making that affects their rights and benefits? Again, the same question. They can participate in decision and policy making affecting their rights and benefits, but excluding therefrom those reserved to management under what is known as management prerogative. Okay. But since we are already here on management prerogative, it may be asked in a problem. Okay. Management, being the owners of business, their prime motivation is profit, and therefore given them is a substantial leeway to do anything on their business, including the price of commodities, who is to be dismissed, who is to be discharged, who is to be promoted, who is to be transferred, and who is, okay, to be promoted, demoted, transferred, and similar acts of management, okay? But this is not an absolute right. In the late 80s, the Supreme Court laid or promulgated in a decision two first limitations to the exercise of this right. Management prerogative should not be exercised in bad faith, because it should be exercised in good faith, because bad faith exercise of this prerogative, okay, is a limitation thereto. Then came another limitation in that decision. It must not be tainted with unfair labor practice. So if an act of management is tainted with unfair labor practice, that is a limitation to this exercise. For example, an active union organizer based in Metro Manila, because of his union activities, is suddenly transferred to Mindanao in order to stop his organizing activities. That is tainted with unfair labor practice. Then in the mid-90s, three other limitations were, okay, in a decision or in decisions by the Supreme Court, outlined three additional limitations and reiterated in several cases thereafter. The first limitation, actually the third, is the limitation set by law. Limitation set by law. So you will learn later that in the choice of the rest day of the employee, that is basically the prerogative of management. But when there is a religious objection by an employee and the chosen rest day by the employer, law is a limitation thereto. Okay. Then the fourth limitation would be limitations set by the collective bargaining agreement. In other words, management's exercise of this right is limited by the provisions agreed upon in the collective bargaining agreement. And lastly, the limitations set by the principles of fairness and justice. That's the fifth limitation. Okay. Then going back to Section 3, Article 13, last year's bar exam was calling the students, it was being elicited from the examinees, okay, the answer to this bar question. There are guaranteed rights under Section 3 of Article 13. And likewise, there are also a statement of policies in Article 3 of the Labor Code as amended. Okay, so basically the question was, what is not stated in Article 3 of the Labor Code as amended that is found in Section 3 of Article 13? So it calls for two laws to find their way in the bar answers. Okay, so that's the question last year. So this provision is Section 3, Article 13 is very important because this is the very provision on protection to labor. This is the very provision that guarantees security of tenure, the right to a living wage, and that it guarantees likewise the right of the workers and employees to self-organization and to engage in peaceful concerted activities. And such other rights, including humane conditions of work. But if you will be asked, in the same provision, what is the only right of management mentioned in Section 3 of Article 13? The only right here is the right of management to a fair return to their investment, to expansion and growth. It's the only mention of the right of management in these constitutional provision. Okay. I am not saying that the other 17 provisions related to labor are unimportant. They are also worth reading, but the concentration must be on Section 3, Article 13. Okay. So these questions on the rights of the workers to participate in decision and policy making, this is the constitutional mandate. Then it is restated in a policy in Book 5, Article 211G, and it is fleshed out in Article 255 of the Labor Code. These are three provisions that should be read together with this right to participate in policy and decision making. Okay. Okay, let's go now to Labor Code proper. The examiner will not ask Article 1, the title of the code. The title of the code. The Labor Code of the Philippines. That was the original Labor Code promulgated in May 1 of 1974. Presidential Decree number 442. But when you will be answering your bar questions, and you would like to cite the Labor Code, you must append, of course, a comma after the Labor Code, and then add the phrase, as amended, to reflect the many changes, revisions, and amendments on the original PD 442. So you place there the Labor Code, comma, as amended. I asked one student in a law school in Taft, and I asked him, what should you append after Labor Code to appear impressive to the examiner in the future? Then he told me, sir, Labor Code, bed as amended. What is bed? Comma, sir. Okay, so it's a comma, okay? Likewise, the examiner might not ask the effectivity of the Labor Code as amended. It was a unique code because it was promulgated on May 1st of 1974 to take effect 6 months thereafter, on November 1, 1974. But before it took effect, 6 months thereafter, another presidential decree suspended the effectivity of Book 4 the provisions on employees' compensation. Okay. Anyway, traditionally, employees' compensation provisions, Book 4, is not included in the bar syllabus. Okay. Then Article 3. Okay. That happens when something like this is held many times. Okay. It becomes defective. Okay. Okay. Are you still awake? You know, in labor lectures, picketing is prohibited strictly. Yung pikit ng pikit ang mata. Okay, so picketing is prohibited. Because if you cannot stop napping there or sleeping there, I will also ask your permission. Can I sleep while lecturing? Okay. Okay, so Article 3 is a provision that should be read again, but take note that the first level of state policies is described by the word afford. And the next level of state policies, the word assure is there, okay? So we proceed now to Article 4. It was asked in the bar last year. So this Article 4 was the source of a bar question last year. So I'm now focusing your attention to this Article 4, again, on the so-called construction in favor of labor clause. In construction in favor of labor clause. Management often questions this provision as giving more rights to labor than to management. In other words, they're trying to tell each and everyone that this is a violation of the Equal Protection Clause. Okay, is that a correct postulate by management? The answer is no, because Article 4 will only apply in case there is a doubt in the interpretation or application of labor laws, rules, and allied legislations. So there is a phrase, in case of doubt. That's why there is no violation of the Equal Protection Clause here, as contended by management. But supposing Article 4 will be worded this wise, deleting therefrom the phrase, in case of doubt, to the effect that all labor laws, rules and regulations, and allied statutes are automatically construed in favor of labor. This time, your answer will be different, because there now appears to be a violation of the Equal Protection Clause because of this automatic interpretation in favor of labor. Okay, so that's number one on the item. Now, for further application of this principle, I'll go to the board once more and bring to the fore three situations that will have to be decided by a labor arbiter or by you as an examinee in September. By the way, in the NLRC, there are only two kinds of labor arbiters. One with a sala, and the other labor arbiter is without a sala, because this labor arbiter reviews decisions or draft reports, which will later on be decisions or resolutions of the NLRC division. So she or he does not have a sala. So strictly speaking, there are only two kinds of arbiters in the NLRC. With a sala, senior; without the sala, sane. Okay, so those are the only two classifications of labor arbiters in the NLRC today. Okay, so here you are, you have, can we move the stage? Okay. Okay, so the cord is there. So we move the blackboard. Okay. So here is case number one, filed before you as labor arbiter. And after weighing the evidence, this is management's position, this is labor complainants. You weighed it at 75% management and 25% labor. Who should win in this case? And is Article 4 applicable in this example. Okay. So here is a case, 75% management, 25% labor. That's why when you will be judges in the future, you should buy a weighing scale, the one that you see in the market or use in weighing rice. Why? Because as judges, you will be tasked to weigh evidence. Okay. So in this case, who will win in case number 1? It is management. And is Article 4 applicable in this case? No, because basic statutory construction tells us that if the law is clear, evidence is clear, jurisprudence is clear in favor of management, there is no room for interpretation. All that the labor judge will have to do is to apply the law according to the literal intents of the legislature. Where do you find that intent? In the law itself. Okay. So Article 4 does not come into play. The law is clear. Then the case B. You weigh the evidence. It is 25% management, 75% labor. Who should win? Who will win in this case? And will you apply Article 4? Of course, labor will win. Article 4 does not apply. Okay? And in the last case, C example, 50% management, 50% labor, and will Article 4 apply in the last case? Okay. So there is now a doubt in the mind of the labor arbiter as to who should win in this case. So Article 4 will now come into play. It is labor that should win in the third case. The Supreme Court had occasion to decide issues on whether or not employer-employee relationship exists or not. Okay. Because if there is no employer-employee relationship existing, then no one can claim the benefits under Book 3 and benefits under Book 5. Okay? Benefits and rights under Book 5 and Book 3. So management will insist that there exists no employer-employee relationship. On the other hand, complainants or labor will insist that there exists such relationship. Given this issue, how did the Supreme Court rule on the diametrical positions of management, insisting no existence of this relationship, and labor, on the other hand, insisting that there exists such a relationship? Supreme Court applied Article 4 in case of doubt, okay? As to the existence of employer-employee relationship, it shall be resolved in favor of its existence, okay? Its existence. So that's Article 4 in brief, okay? Then we go now to a possible question that will be called from Article 5. So Article 5 simply is the rule-making power of the Secretary of Labor, not only the Secretary of Labor, and other officials tasked to implement the code. Okay, that's Article 5. In one case, the Employers Confederation of the Philippines versus the National Wages and Productivity Commission, this rule-making power is also known as the power of subordinate legislation. The power of subordinate legislation. What do you mean by this power of subordinate legislation? This is a delegated power from Congress because of the expertise of administrative agencies. They are entrusted, okay? This delegated power of rule-making, formulate the same, and implement these rules and regulations. Okay, so that's the rule-making power of the Secretary of Labor and these other officials tasked to implement the code. But the examiner may proceed further. How do you know that a rule or regulation issued by the Secretary of Labor or any of these attached agencies of the Department of Labor, okay, is a valid rule or regulation? So in the famous case of Insular Bank of Asia and America, the presidential case in this, including sister cases, the Supreme Court laid the test of a valid rule or regulation. So let's go to the board once more. So Article 5. Okay, Article 5. The basis for rules and regulations to be issued by administrative agencies is a substantive. Mic test. Okay, it's working. Mic test. Mic, test, test. Okay. So, it's working, okay. So the basis. Okay, can you see the board now? Of course you can. Okay. So the basis for rules and regulations issued is the substantive law passed by Congress. And the rules and regulation must conform to that substantive law passed by Congress. You can use this also in your administrative law. Okay. Now, supposing there are 5 categories of employees that's in the substantive law entitled to certain benefits. In the guise of so in the guise of rulemaking, let's say the Secretary of Labor. Okay. Okay, here in the guise of rulemaking, the Secretary of Labor Okay, maybe it will work. So in the guise of rulemaking, the Secretary of Labor now adds 1 to this category of employees entitled to this benefit. What did the Secretary of Labor do? He expanded that which is provided for under substantive law via the rules. Or if he reduces this by 1, what did the Secretary of Labor do? He withheld more than that which is provided for under substantive law. So what's the test? Any rule or regulation issued by the Secretary of Labor and administrative agencies that withholds or delimits more than that which is provided for under substantive law is an ultra vires issuance. So this is the first case of Insular Bank of Asia and America, where the former Minister Blas Ople removed from the coverage of holiday pay monthly paid employees. So in the case of Insular Bank of Asia and America and sister cases, the Supreme Court ruled that that is an ultra vires issuance in the guise of a rule issued by the late Minister Ople. So it was ruled as an ultra vires. Okay. So when you will be citing cases of similar import in the future or in your bar, you just say, in sister cases decided by the Supreme Court. In a plethora of cases would be impressive, or in a coterie of cases. That is impressive. But do not cite, in brother cases decided, do not do that. Okay, that's not allowed. And do not imitate one labor arbiter who, wanting to impress the NLRC divisions and the Court of Appeals and the Supreme Court thereafter, used the word, in an avalanche of cases decided by the Supreme Court. Okay, so don't use avalanche. Okay. So here, the conclusion is simple. What's the test? Any rule or regulation that withholds more than that which is provided for under substantive law, or delimits more than that which is provided for under substantive law, is an ultra vires issuance. So don't forget ultra vires. But how do you pronounce ultra vires? Is it ultra vires or ultra vires? Okay, the latter is impressive. And I'm reminded by a pupil in the Visayas asking the teacher once, "Ma'am, how do you pronounce the word either? Is it either or either?" Then the mom said, well, either of the two will do. Okay. So there are three ways of pronouncing the word either. Either, either, either. Okay. Now, there's an additional, this Article 5 provides for the effectivity of rules and regulations issued by the Secretary of Labor and these other agencies. It takes effect 15 days after its promulgation in a newspaper of general circulation. 15 days after promulgation or announcement in a newspaper of general circulation. But there is an additional requirement here in order that the rule or regulation may be legally unenforceable. So in one presidential case once more, in the case of Pasay versus Torres, the Philippine Association of Service Exporters Incorporated versus Torres, a former Secretary of Labor, the Supreme Court ruled that failure to furnish an office of the UP Law Center, it's called the ONAR, Office of the Administrative Register, ONAR, okay? That rule or regulation is legally unenforceable. In other words, the effect of failure to furnish copies of these regulations issued by administrative agencies, like in the case of that POA circular issued by Secretary Torres, being then the chairman, ex officio chairman of the POEA, Supreme Court ruled that that issuance is legally unenforceable for failure to furnish the UP Law Center, particularly that office of the ONAR, Office of the National Administrative Register. Remedy, furnish the ONAR copies of the rules and regulations. And of course, these rules and regulations that must be furnished that office must have an effect on public interest. It may have effect on vested rights, so that the Secretary of Labor promoting a janitor from ground floor to sixth floor, that you need not furnish the UP Law Center a copy of that memorandum. Okay, so that's Article 5 in brief. Now, Article 6 is a very brief provision, but as we discuss Article 6, I will now introduce to you labor standards, portion of labor standards, and a topic known as areas of jurisdictional conflict. Areas of jurisdictional conflict. Maybe from this, one or two bar items may be asked. Okay. So Article 6 starts with an upper case A and ends with a lower case y. So the subheading of Article 6 is applicability, period, and then dash. Okay, so applicability. Okay. So if questions will be asked on Article 6, the examiner would like to elicit one thing from you. Given these facts, given these kinds of employees, are they covered by the provisions of the Labor Code as amended? Okay. So this will now be the areas of jurisdictional conflict. So let's go to the first kind of employees. Employees of line agencies of the government. So employees of line agencies. What are this? Okay. So we go basic. So that, okay. So the first one is line agency employees. Employees of line agencies, for example, employees of the DOL, the DTI, the DNR, etc.
But etc. is not a line agency. Okay, so I'm sure of that. Okay. So here, you'll be asked, employees of the DOL, for example, A was dismissed. And A, after undergoing the internal processes within the DOL, is now confronted where to go next. Will he go to the labor arbiter or any of the labor tribunals versus the Civil Service Commission? Okay, so after he already have undergone the internal process within DOL, he will now make a choice. He will now go to the Civil Service Commission, and the basis for your answering why or because, is a provision which we sometimes do not notice. It's Article 276 of the Labor Code. Okay? So employees of line agencies are covered by civil service laws, rules, and regulations. It's based on 276 of the Labor Code. When you will be answering your bar questions, please read at least the questions twice. Okay, so we said, employee of DOL A, if aggrieved, will have to go to the Civil Service Commission on the basis of Article 276 of the Labor Code as amended. Why? Because if your eyes would be merely focused on the word DOL and jurisdiction is being asked, don't answer immediately Civil Service Commission as having jurisdiction. Because the examiner added two words to the question which you have not noticed. DOL Philippines Incorporated. Okay, so the answer will be different. So between the labor arbiter versus the Civil Service Commission, Civil Service Commission has no jurisdiction. The point is, read the problems twice, at least. Okay. The next would be employees of GOCCs. I know you know this, but for emphasis, I'd like to discuss employees of GOCCs. 5 years ago, or about 6 years ago, because an overflowing question in labor, this was asked in political law. Employees of government-owned or controlled corporations. So that you will not belabor yourself in answering the bar problem, if one will be asked on GOCCs, you will determine immediately whether the GOCC has an original charter or without original charter. Okay? But how do you know that the GOCC has an original charter? These are your indications. Okay? But before we go to the indications, there is a provision in the 1987 Constitution zeroing on the original charter. That's Article 9-B. Don't forget this article. Paragraph 2, subparagraph 1, on the original charter. Okay? How do you know that a GOCC has an original charter? Okay. During the old Congress, prior to the declaration of martial law, a GOCC may have been created by virtue of a law, by a Republic Act. Or, during martial law, it may have been created by virtue of a presidential decree, because during martial law, the late President Marcos had law-making powers. And these are the laws that he can legislate at that time. Proclamations, orders, decrees. This is the decree. Instructions and other acts are part of the law of the land. Proclamations, orders, decrees, instructions, and other acts. So the second fiat may be by virtue of a presidential decree. Or, during the Freedom Constitution, the late President Aquino issued various executive orders creating GOCCs. So an EO during the Freedom Constitution was one mode of creating GOCCs. And when the Congress presently there in Batasan convened after pursuant to the 1987 Constitution, it may now be created GOCCs by virtue of a Republic Act once more. Any of these indications will be a guide to your answer that a GOCC with an original charter, okay, employees thereof, under, so in our area of jurisdictional conflict, let's put it here, okay, GOCC with OC, original charter, labor arbiter versus the Civil Service Commission or labor tribunals. It is the Civil Service Commission that has jurisdiction on the basis of Article 9-B, paragraph 2, subparagraph 1. Okay. So aggrieved employees of GOCCs with original charter, after internal processes had been completed within the level of the GOCC, he can go to the Civil Service Commission next with original charter. But if the GOCC is without original charter, the GOCC was registered where? With the SEC, okay, with the Securities and Exchange Commission, under the General Incorporation Code, okay, under the corporation law. Then the GOCC is registered with the SEC, okay, Civil Service Commission has no jurisdiction, but rather the labor arbiter or labor tribunals have jurisdiction over GOCCs registered with the SEC, so that in the jurisdictional conflict of the labor arbiter versus the Civil Service Commission, labor arbiter has jurisdiction. The employees previously of the University of Life Foundation registered with the SEC were covered by the provisions of the Labor Code as amended. Today, the Food Terminal Incorporated, still existing in Taguig, are covered by the provisions of the Labor Code, so were the Bliss Marketing Corporation, all registered with the SEC. The employees, even in the University of Life case, I was able to organize unions under Book 5. Okay, so even if it took 15 years for them to await for their benefits after a Supreme Court decision, the point is they were able to cite the Labor Code provisions as amended. Okay, so please take note of the two kinds of GOCCs. So if this will not be asked in labor, it can be asked in political law. The third kind of personnel in a company, okay, will be corporate officers. Again, if this will not be asked in labor, this will be asked in mercantile law. Corporate officers, okay. And who are corporate officers? Okay. Okay. I'm writing this because of its importance, okay. So third would be corporate officers. The bigger the letter, the more chance that it will be asked in the bar, okay. Okay, so corporate officers, okay. There are two main documents which can be the basis for your correct answer in the bar as to corporate officers. Okay. Now, who's a corporate officer? First, you go to the bylaws of the corporation. Okay, supposing the position of vice president for controllership is in the bylaws, and A is interested in this position, what should be done? Number one, he should be elected or appointed in that position by virtue of a board act, approval of the majority of the board of directors. And supposing after 2 years, he was not reappointed, it must likewise be by virtue of a board act. His non-appointment and non-reappointment, okay, should be by virtue of a board act. A, therefore, is a corporate officer, okay. And if A is aggrieved, and A will consult you, where will I file my case? Then you will remember that there is a new securities regulations code of 2000. which took effect 19 July of 2000. Okay? So prior to this date, the only jurisdictional conflict is between the labor arbiter, the labor tribunal, based on so many cases that reached the Supreme Court, versus the SEC prior to 19 July 2000. Okay, so it was then the SEC that had jurisdiction. But after 19 July of 2000, by virtue of the new Securities Regulations Code, it's now the appropriate regional trial court. By virtue of this law, the RTC commercial courts have now jurisdiction over intra and intercorporate controversies, thereby removing from the SEC the power or the mandate to take cognizance of inter and intra-corporate controversies. Okay. So now, all readings, all cases that you'll be reading in your books that points to SEC as having jurisdiction over corporate officers, these were correct when they were decided. There was no new securities regulations law at that time. Now the appropriate, don't forget the word appropriate, regional trial court, commercial court has now jurisdiction over intra and intercorporate controversies. Okay. So the first document that will guide you to correct answer whether A is a corporate officer is the bylaws of the corporation. The position is written there. Okay. Then if it's not in the bylaws, the second document would be a board resolution. A board resolution creating, for example, the position of Vice President for Labor Relations. Okay. And if B is interested in this position, he must not only be appointed, first appointed by virtue of a board act, or after 2 years, not reappointed, it must likewise be by virtue of a board act. In that sense, B being aggrieved, okay, may file his case now with the appropriate regional trial court, no longer with the SEC, okay, because of the new Securities Regulations Code, okay. So it must likewise be by virtue of a board act, appointment, non-reappointment, by virtue of a board act. He, A and B are corporate officers, okay. And if aggrieved, file with appropriate, the case with appropriate regional trial court. So to emphasize, intra-corporate controversy is a controversy within the corporation. And if the controversy is an inter-corporate controversy, it's a controversy outside of this corporation with another corporation. Okay. Supposing there's a controversy in this review class. This is an intra-review class controversy. There's a controversy with another review center in Moraita. That is inter-review center controversy. But supposing it involves a course, a subject, so you call that, those quarreling within that course would be an intra-course controversy. Okay, I'll not mention anymore the other kind of controversy. Okay, it is self-explanatory. You even thought of it before I thought of it. Okay, so just to emphasize the importance of inter and intra. Okay, third example. In this company, there is a chief accountant. The chief accountant is Miss C. Okay? Her position is not in the bylaws. Her position was not a board-created position. She was appointed by the president of C Corporation. And after 1 year, she was dismissed or terminated by the same president of the corporation. Given this facts, this factual milieu in your bar, where to file this? Where will the chief accountant file the case? Labor arbiter, labor tribunal versus the SEC versus the RTC. Where should chief accountant C file her case? Of course, she made the determination that she is not, or she was not a corporate officer. And therefore, having made a determination that her position was not in the bylaws, it's not a board-created position, she was not appointed by virtue of a board act, only the president of the corporation. She was not dismissed, not by virtue of a board act, but only by the same president of C Corporation. Therefore, your conclusion is the labor arbiter or the appropriate labor tribunal will have jurisdiction over the chief accountant C, she being not a corporate officer. Okay. So that should be clear at this point in time. Now, in the mid-2000, okay, so don't forget our basic premise. The position must be in the bylaws. It must be a board-created position. And that person should be appointed by virtue of a board act. Non-reappointment should likewise be by virtue of a board act. Non-reappointment of either A or B is an intra-corporate controversy cognizable by the appropriate regional trial court. Okay. Why do I say add the word appropriate? Because there are some RTCs which is not appropriate. Let's say the company is located in Quezon City, and the case is filed in an RTC in Sulu. That RTC, commercial court in Sulu, is not an appropriate RTC. Okay, so that emphasizes the importance of the word appropriate. Okay, I'm calling your attention to a case in the mid-2000, the case of Nakpil versus IBC 13. Okay, Mr. Ren insists that he is just an ordinary employee. Therefore, the labor arbiter or the appropriate labor tribunal should have jurisdiction over his case. Okay, but here are the facts of this case. Mr. Nakpil was appointed by the general manager of IBC 13. And his appointment was elevated with the board of directors of IBC 13, which board approved the appointment of Mr. Ren. So this case reached up the Supreme Court. Mr. N still stands on the postulate that this is just an ordinary employee, not a corporate officer, because his position is not in the bylaws. It was not a board-created position. In this case, the Supreme Court ruled that with the approval of the appointment made by the general manager of IBC 13, Mr. N is a corporate officer, and if aggrieved, he should go to the appropriate regional trial court, okay, to prosecute his case. Okay, not with the labor arbiter, not with the any labor tribunal. Okay, so that's the case of Mr. Nakpil. It's not in the bylaws. It's not a board-created position. So don't forget bylaws. The bylaws governs how the corporation is to be run. Okay, it's the Bible for a corporation. But in the house for married men, what governs this married man? Okay, in the house, you know who governs? Not bylaws, but in-laws. Okay. Okay. So that's on corporate officers. The next kind of employees would be employees of international organizations. Employees of international organizations like the Asian Development Bank, employees of specialized agencies of the United Nations, for example, the World Health Organization branch located in UN, okay, are their employees covered by the provisions of the Labor Code as amended. Okay. There were so many cases already on this, like the case of Mr. Lazaga versus SIFDEC, the case of Department of Foreign Affairs versus Labor Arbiter De Castro. Okay. What I'm trying to emphasize here is employees of international organizations like the Asian Development Bank, the Labor Code provisions do not apply to them. Okay. So if A, or let's say if Miss D, an employee of ADB was dismissed, he cannot go to the appropriate regional arbitration branch of the NLRC or here in NCR because the NLRC has no jurisdiction over the case of Ms. D, an employee of ADB. So what's the remedy of Ms. D? There are internal mechanisms within ADB for the adjustment of the dispute of Ms. D with Asian Development Bank. And why are labor laws, and to some extent municipal laws, not applicable to international organizations like the Asian Development Bank? What's the reason? Okay. You know, international organizations may be created either by virtue of a bilateral agreement, two countries are involved, or international organizations like the ADB was created by virtue of a multilateral agreement. And of course, when this was signed by the authorized representative of the signatory countries, it was the intention of those signatories that in the case of ADB, based in Ortigas, okay, that the host country, the Philippines, will leave their operations unhampered. Aside from the charter and the general creation of ADB, okay, aside from the Philippines should not hamper their operations, the Philippines should leave unhampered their operations. This is the other reason why they are immune from suits. It was the intention of the signatories to that effect. Okay. Similarly, employees of specialized agencies of the United Nations, labor code provisions do not apply to employees of the World Health Organization based in United Nations Avenue. Okay. Labor code provisions, and to some extent, I've said municipal laws do not apply to these specialized agencies and international organizations. Okay. And lastly, on Article 6, we will add areas of jurisdictional conflict as we go along. Okay. Then the last topic on Article 6, before we proceed to the law versus employment, is the application of the reasonable causal connection test as laid down by the Supreme Court in several cases. So here is a jurisdictional conflict on how to determine where should certain money claims be filed. Should it be filed with the labor arbiter or should it be filed with the appropriate regular court? Okay, so this is the reasonable causal connection test. And as we discuss this is already an introductory portion of the lecture on labor standards. Okay. So the last one would be money claims. Okay. Should this be filed with the labor arbiter, labor tribunal, versus the regular court? Okay. So here is Miss X, an employee, for example, of Toyota Motors Corporation. Okay. She is claiming that she was not paid her salary differential. What's the salary differential? So here is the prevailing minimum wage, and Miss X is receiving below minimum wage. The difference is known as salary differential. She's claiming that. Okay. She's also claiming that she was not paid her overtime. Okay, so she's made to work for 8 hours. This is 8 hours work. And then 1, 2, 3 hours after his work shift of 8 hours, he's made to render overtime, but she was not paid this overtime. So if one works for 8 consecutive hours and is made to further work for additional, in this example, 3 hours, she's entitled to overtime. So she's claiming unpaid overtime. There are times that Miss X's work schedule ends at 10 p.m. So 10 p.m. she worked for 8 hours, okay? Then she's made to work additional 3 hours on overtime. So remember, she is not only entitled to overtime, but night shift differential pay. Why? Because the last 3 hours work in overtime is also within the night shift, okay, or graveyard shift. So if one works from 10 p.m. up to 6 a.m. the next day, he's entitled to night shift differential pay and overtime. So she's claiming non-payment of overtime and night shift differential pay. There was only one bar examination year where a problem was asked on how to compute overtime, okay? So when we reach overtime in Article 87, I'll teach you how. Now in this third example, claims. Supposing overtime coincides with night shift work, how do you compute night shift? You compute night shift first, or you compute overtime first? The correct procedure is compute overtime first, and the basis of the hourly overtime rate, okay, depending whether this work was done in the ordinary working day of the employee, times 25%, times 10% in case of overtime. 25 if this is the ordinary working day to get the hourly rate, and then 10% thereof would be the night shift differential pay. So the point that I'm telling you, compute overtime first, then night shift second. It's not the other way around, okay? Night shift is also known as graveyard shift, okay? And when one works during the graveyard shift, may a personnel in the company claim graveyard pay. There is no graveyard pay in Book 3. There is only night shift differential pay. Supposing the employees of Loyola Memorial Park, okay, their employees work from 10 p.m. up to 6 a.m. the next day. That's their work shift. Can they claim graveyard pay? Of course, there is no graveyard pay in Book 3. However, if these employees of Loyola Memorial Park may volunteer to be buried alive, maybe they're entitled to a graveyard pay. Okay. So that's the third claim. Okay. Now, she's also claiming premium pay. Okay, so number 4. Okay, she's also claiming premium pay. So there are 3 examples of a premium pay. What's a premium pay? There are days, for example, it's the rest day of the employee. It is a special day declared by Malacanang as a non-working holiday. Or it's a regular holiday. It's a May 1. The employees are not supposed to work on this day. But having been made to work on this day, they are entitled for the first 8 hours an additional compensation. That compensation, additional compensation, is known as a premium pay. So if one is made to work on a day that he or she is not supposed to work, having been made to work, aside from regular wage, he is entitled to premium pay. Okay, so let's illustrate premium pay. These are the claims. Okay. So it's the rest day of the employee. The employee is not supposed to work on X on her rest day, but she was made to work on her rest day. So for working on a day that she is not supposed to work, aside from regular wage, Miss X is entitled to an additional 30% for the first 8 hours of regular wage. This additional compensation of 30% is known as a rest day premium pay. Okay. It is a special day declared by Malacanang as a non-working holiday. X is not supposed to work on this day because it is a non-working holiday. So as a general rule, one cannot be compelled to render overtime, subject to exceptions. As a general rule, one cannot be compelled to work on one's rest day, subject to certain exceptions. So here is a special day So X is entitled to her regular wage for the first 8 hours but plus 30% thereof. This 30% of regular wage is known as a special day premium pay. It is a special day declared by Malacanang as a non-working holiday, and it is the rest day of the employee at the same time. So as a rule, X will not have to work on this day, but having been made to work, she is entitled to regular wage plus 50% thereof for the first 8 hours. This 50% of regular wage is known as the rest day, special day, premium pay. And if one is made to work on a regular holiday, okay, as a rule, you cannot be compelled to work on a May 1 or on a Christmas Day. Okay, and having been made to work on a regular holiday, the employee is entitled to regular wage plus 100% thereof. This 100% for the first 8 hours is in the concept of a regular holiday premium pay. So all of these are now being claimed by Ms. X. So we will now go to the test that I have mentioned. So what is this reasonable causal connection test in the determination of money claims? Okay. So the reasonable causal connection test. Okay. So on these claims of Ms. X, whether it is the labor arbiter, labor tribunal versus the regular court that has jurisdiction over this case, you will be asking the question. These claims of Ms. X, is there a reasonable causal connection of Ms. X money claims to what? To employer-employee relationship. In other words, were these amounts being claimed by Ms. X, were these earned while she was an employee of Toyota Motors Corporation? If your answer is in the affirmative, if your answer is a decidedly yes answer, then you can conclude that it is the labor arbiter that has jurisdiction, given a multiple choice. Next year, I hope you will not reach that year. Nobody should take the exams next year. Okay, finish it now. Okay. So it is the labor arbiter that has jurisdiction because you have established the reasonable collection of these money claims with employer-employee relationship. And besides, we said preliminarily that no one can claim Book 3 benefits and some rights under Book 5, including Book 6 and post-employment, if there is no employer-employee relationship. So X, a properly filed case with the appropriate regional arbitration branch of the NLRC. Okay. And another example before we leave Article 6 would be the case of a sales manager. Okay. Let's say this is the Recoletos Motor Sales Corporation. Okay. Sales manager of Recoletos Motor Sales Corporation. This corporation extended to sales manager E 50,000 for spare parts and 25,000 for service and scar, total 75,000 bucks. Okay. After 2 months, sales manager E refused that his salary be deducted by Recoletos Motor Sales Corporation. The president of Recoletos Motor Sales now approach you, Tori, where should we file our case? In this particular case, is it before the labor arbiter or before the appropriate regular court? Okay. The bad advice is, why don't you go to Rex Bookstore and find a book that will answer your question? That is a bad advice. Okay. 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 So here you will apply the test. Is there a reasonable causal connection of this 75,000 by way of loan, extended to the sales manager by way of loan to employer-employee relationship. Was this earned money by the sales manager during the relationship? Okay, of course the answer is no. There is no reasonable causal connection of this 75,000 pesos to employer-employee relationship. This was not earned by the sales manager. So this is a simple sum of money. A case of recovery for a simple sum of money that should be filed with the appropriate regular court, not with the labor arbiter. So that's on the reasonable causal connection test. Because there may be items, there may be cases where jurisdiction may be difficult to discern where to file. And if that's pertinent to money claims, then establish, is there a reasonable causal connection of this money claims with employer-employee relationship? If yes, then the safe answer is file this with the labor arbiter or with the appropriate labor tribunal. Okay, so that brings to the fore the first 6 provisions, the general provisions on the labor code as amended. Okay. You know, you may ask the question, why are you all here? What's the quest? What's the reason for being here? Okay. You know, you are here because of the most expensive punctuation mark in the world. You spend time, money, effort, sacrificing sometimes time with your loved ones and one's love. Okay, so because you're here for the quest of that period after ATTY. That's the reason why you are here, okay? An expensive punctuation mark. Remember, September's quest for 4 Sundays is a period, not a comma, not an exclamation point. Because exclamation point, well, there is a period below. There is an exclamation. Well, okay. So it's also not a question mark, okay? It's not also a colon, because a colon has 2 periods, okay? So how, okay. And how should you answer your bar exams? Simple advice. First, if you know the law verbatim, cite the law and jurisprudence. But you will just say, in a case or in a coterie of cases, plethora of cases, decided by the Supreme Court, then. So verbatim citation of the law, that is photographic memory. If not, next would be substantial citation of the law and jurisprudence, and the ratio decidendi of an applicable jurisprudence. That is known as photogenic memory. Okay, okay. And then the third one, if the 2 will not work, the next would be, what is fair and just? Okay, it can also be a basis for an answer. 4th would be common sense. Common sense. 5th would be any sense. Okay. My point is, do not leave any blank portion of your test paper. You know the effect? Full deductions on that blank portion. Okay. So simply and briefly, that's how you will do it. Last year's bar exam was too lengthy that you had already no time to explain more than 3 sentences the answer. So you have to go direct to the point. Labor was a very long exams last year with A, B, and C. Okay. So we go now to the laws on overseas employment. You expect 2 or 3 questions, maybe 2, on the laws on overseas employment. Caution. If you find cases of note, not only in labor, but in other subjects, try to study, even if it is outside of the cutoff date of 30 June 2009. Because last year, although the case was very much outside of the cutoff date, The cutoff date is 30 June of 2008. This case, which was decided March 2009, okay, was a case of note, was us in the bar, even if it was outside of the coverage of cases. Okay, I'm referring to the case of Serrano versus Galant Maritime, okay, decided March of 2009, because it may be asked again. And in relation to your Section 10 of the Migrant Workers Act, you put a small cross or an X on paragraph 5, because the unexpired portion, or 3 months, whichever is less rule, is no longer a good provision in Section 10. That was declared unconstitutional by the Supreme Court on the ground that to distinguish a contract, an OFW contract of less than 1 year and another contract of at least 1 year or more, according to the Supreme Court, is not based on a valid classification or a distinction. That was the reason why it was declared unconstitutional. So what's the distinction of a contract between less than a year and at least 1 year or more? So that portion of Section 10, paragraph 5, should now be crossed in your book. So even if you have crossed the same, this is a free country. You can read and read repealed provisions of law, but nobody can stop you. Okay. So section paragraph 5. Okay. Now, what are the sources of the law on overseas employment? Sources. Number 1 would be Article 12 up to Article 39 of the Labor Code as amended, but many of these provisions had already been repealed or amended by various laws. Okay, number 2 source would be Republic Act number 8042, otherwise known as the Migrant Workers Act of 1995. Okay, and of course, the governing rules latest of the POEA. Okay, so 3 sources on the laws on overseas employment. Okay. So what are notable items that may be asked on overseas employment? Okay. Number 1 would be the definition of a migrant worker. It may be asked in a problem, and the components of the definition may be asked for you. Okay, so let's attempt to define a migrant worker. Who is a migrant worker? One who was engaged, past. One who is being engaged, present. And one who is about to be engaged, future. Where? Okay, this is one phrase that you should not forget. In a country where he is not a legal resident, because if he's a green card holder, he's not within that purview. So one who was engaged, presently engaged, and about to be engaged in a country where he is not a legal resident. Okay, and what does he do there? Well, he's in a country that he is not a legal resident. He is engaged in activities. But what kind of activities? These are remunerated activities. Meaning to say that the OFW is paid for the services that he renders in a country or in a place where he is not a legal resident. Okay. And then the next definition that may be asked from you would be gender sensitivity. Okay. So there are inequalities or iniquities between men and women. And having recognized that inequality or iniquity, something positive is done about it. That's why in government offices today, a certain percentage of the budget is reserved for gender sensitivity programs. Okay. In the United States, this is in the nature of an affirmative action law. in the United States, the Negroes were discriminated for centuries. And came the segregation. There must be laws that will have to be passed by the U.S. Congress, which appears to be giving more rights and opportunities to blacks rather than to whites. Okay. Until they equalize, affirmative action laws will have to be, the rights will equalize, will have to be passed. This is in the nature of affirmative action laws. So, gender sensitivity. Do you still believe in the argument that women are of the weaker sex? Okay. I have seen friends at 2 a.m. to 3 a.m. in the morning thrown out literally in the windows, okay, in their windows. And if you are not a believer that there are unidentified flying objects, okay, there are at that time, okay, saucers, plates, spoons are flying, okay, at 2 or 3 a.m. in the morning, okay. And for would-be lady lawyers, I'm not giving you this tip, okay. Usually, male lawyers come home late, okay, and they have so many reasons why, okay. One client of ours, okay, she was waiting for the husband, lawyer, and upon arrival, poured gasoline on the husband lawyer. And then he has the match. Where did you come from? My God. The husband lawyer even admitted that he was a participant in the execution of Andres Bonifacio in Maragondon, okay? Okay. Okay, so gender sensitivity laws. And the third one, just have an idea, overseas Filipinos, okay? The narrowest definition is Filipinos in distress. That's in Republic Act 8042, but this includes overseas Filipinos include those who have medical, social, legal problems, including their dependents, okay? So that's an overseas Filipinos. But this question will not be asked by the examiner. Are overseas Filipinos overseas? Okay, so the examiner will not ask that, okay. Okay, next would be on illegal recruitment. For sure, a question will be asked on illegal recruitment. There are two kinds of illegal recruitment. The first one is simple illegal recruitment. And the other kind would be qualified, classified further into two: illegal recruitment by a syndicate and illegal recruitment in large scale. Okay, so you will be asked, how many perpetrators are there in syndicated illegal recruitment? Okay, there are at least 3. It can be more. And what do? They conspire, they confabulate to commit any of the acts of illegal recruitment enumerated in Section 6, which was a carryover of the enumerations in Article 34 of the Labor Code. But Section 6 is longer by 2 enumerations, okay? And how is it committed? So these are the provisions. Section 6, in relation to Article 34, add Article 32, which is also an act of illegal recruitment, collecting fees over and above the 1-month basic salary. In the recruitment parlance, you call this illegal exaction. And how are these committed? Then go back to the definition of recruitment and placement in Article 13B. 13B, okay. So one who canvasses, utilizes, transport, refers, okay. All these are acts of illegal recruitment, pointing to how these acts of illegal recruitment are committed, okay. So please take note of 13B in relation to Section 6, okay. So how many victims should there be in syndicated illegal recruitment? Victim should at least be 1. The standard is 1. It can be more, okay. Okay, large-scale illegal recruitment. How many perpetrators should there be in large-scale illegal recruitment? What's the standard? At least one. Large-scale illegal recruiter, it can be more, but it's enough that there is one large-scale illegal recruiter. Victims, how many victims should there be in large-scale illegal recruitment? At least three. At least three. But each one of these three, whether recruited individually or collectively as a group, the total should be three. Okay. Each one of these three should prove their cases individually against this single large-scale illegal recruiter. Okay. What are cases of note on large-scale illegal recruitment? In one case, there were three complainants, two actual victims of illegal recruitment by, let's say, large-scale illegal recruiter, alleged large-scale illegal recruiter A. Okay. The third complainant was a police officer, but not a recruit, not a victim. Okay. Issue. Is there large-scale illegal recruitment in this problem? The answer is no. What was committed is only simple illegal recruitment. Because while it is true that there are three complainants, the policeman was not a victim. Technically, there were only two victims. Hence, there is no large-scale illegal recruitment here. You know the effect? Large-scale illegal recruitment, that's non-bailable. Okay? In this case, since there were only two victims, only simple illegal recruitment was committed. Okay. In another case, one victim of illegal recruitment executed 7 or 8 complaints against one alleged illegal recruiter. Okay. Is there large-scale illegal recruitment in this case because there are 8 complaints executed by one victim? Okay. What was committed here is only a case of simple illegal recruitment. The number of complaints by one single individual does not upgrade this act of illegal recruitment into large scale. So the number of complaints would be immaterial. What is material would be the number of victims who individually must prove that they were victims of this alleged large-scale recruiter. And then their total is at least 3. At least 3. Okay. Okay, that's on Section 6. The difference of Article 38 and Section 6 today on illegal recruitment, previously, under Article 38, only non-holders of authorities, only non-licenses could be liable for illegal recruitment. But under Section 6 of the Migrant Workers Act, even licensees or holders of authorities could be liable for illegal recruitment. For example, a license of a placement agency was suspended, but despite such suspension, it continues to recruit. Or it was already banned from participating in the manpower export industry or in the deployment of overseas workers. Okay. So, even licensees and holders of authorities may be liable for illegal recruitment under the Migrant Workers Act of 1995. Okay. So that's Section 6. Please mark Section 6 and Section 7 of the Migrant Workers Act. Section 7 is the provision on penalties, virtually amending the penalties under Article 39 of the Labor Code as amended. Okay. Please take note that as you read this section, that there are 2 levels of penalties. Lower level penalties, but it has a maximum. And then next would be a higher level of penalties with a maximum. So there is a range. Okay. And in the same provision, if the person recruited is less than 18 years of age, what maximum will you impose? maximum of life imprisonment and a fine of 1 million, not exceeding 1 million, or the maximum of the lower level penalties. Okay, submittedly, it's the maximum of the lower level penalties in Section 7. But when the act of illegal recruitment is committed by a syndicate, committed in large scale, amounting to economic sabotage, it's provided there that the maximum will be imposed. It should be the maximum of the penalties stated in the second part of this Section 7, which is the maximum of life imprisonment or a fine not exceeding 1 million or both. Okay, so that's on Section 7. Okay. Then other provisions of note would be, before we discuss the Serrano case, would be on the question, who are disqualified from participating in the recruitment of workers for overseas deployment. So I'm calling your attention to Section 8. Section 8. Employees as well as relatives of those working in the Department of Foreign Affairs, in the OWA, in the POEA, and the DFA, okay, or the DOL, I should say, DFA, OWA, POA, and the DOL, are disqualified from participating in the deployment of overseas workers, okay? They are disqualified. Up to what extent? In so far as the relatives of these employees are concerned, up to the 4th degree of consanguinity or affinity, okay, by blood or by marriage, okay. A former director of licensing, or presently a director of licensing now at the POA, has a common law wife. What do you mean by common law? How common? Okay. So, is that common law wife disqualified from participating, okay, in the recruitment of overseas workers for deployment abroad? No, because she does not come within the purview of 4th degree of consanguinity or affinity, much more on affinity. She's not disqualified, okay? Okay. Then the next would be Section 9 of emphasis, okay. Venue of illegal recruitment cases, venue. So the victim has two choices of illegal recruitment. And Section 9 is instructive on these two choices. First choice, of the RTC, where she may file where her case will be filed. RTC of the place where she was recruited, or the address of the recruitment agency, or the RTC of the place where she permanently resides at the time of recruitment. So she has two choices. And the first RTC that will take cognizance of her case will necessarily exclude the other. So that's on venue. And then before we take Section 10, let's go to Section 28. What do you mean by the country team approach? What is this country team approach? Section 28. It simply means that organic employees of the Philippine government, whether they belong to some departments in the Philippines, organic employees of some departments or agencies, when deployed abroad, okay, on a foreign assignment, on a country basis, they are under, for example, those deployed in the United States as labor attaché, trade attaché, press attaché, or okay, tourism attaché. On a country basis, they are under the leadership of the ambassador. If there is no ambassador there, under the consul general. If no consul general, consul. And it is required that they should act as a team consistent to national interest. Otherwise, the ambassador may recommend to the DFA secretary the recall of this employee who is not cooperating as a team member, and that this employee deployed in that particular country working, her actions are not consistent with national interest. So DFA secretary now will notify the agency head concerned here on the recommended recall of that organic employee of this particular agency. This was brought forth during the case of Flor Contemplacion, because our employees in Singapore were not acting as one. They were not acting consistent to national interest. That's why Section 28 found its way in the Migrant Workers Act of 1995. For the purpose of your bar, the Migrant Workers Act took effect 15 July of 1995. 15 July of 1995. Okay, and before we go to Section 7, let's see how this gallant maritime case applies. Okay, and how was the application of the superseded unexpired portion or 3 months, whichever is less rule, which is no longer a good rule. So allow me once more, before we take a short break, to illustrate in any of these 5 scenarios how you will attack the problem on this unexpired portion, okay, of the OFW's contract. Okay, so for example is, okay, unexpired portion. Before we start with these 5 examples, before any unexpired portion may be awarded by the labor arbiter under Section 10 of the Migrant Workers Act, labor arbiter, okay, has jurisdiction over money claims. It is requisite, it is a requisite that the dismissal must have been illegally effected by the foreign employer. So dismissal must have been illegally effected. The dismissal was illegal before the labor arbiter can award any unexpired portion of the contract. Because if the dismissal was not illegally affected by the foreign employer, then there's no basis to award any unexpired portion of an OFW's contract. Okay, let's illustrate now. So we start with the case of Seaman A. Seaman A, he has a 9 months contract. 9 months. By the way, a seaman is also a seafarer, okay? A mariner. And what is the plural of seaman with an A? Plural. Seamen. That's not the way you said seamen. Okay, it's seamen. Okay. Okay. And how about a female seaman? How do you call a female seaman? Sheman? Okay. 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 Here is a case of Seaman A. He started working in the vessel. Who is a seaman, by the way? A seaman is one recruited by a manning agency. And this seaman now works in a vessel plying the high seas. So that's the place of work, in vessels plying the high seas. Okay. So he began working in the vessel, okay, and their vessel was docked somewhere in Singapore. On the 30th day, Seaman A was forced to disembark. Okay, so there was forced disembarkment by the ship captain of A. So A now filed a case where, under Section 10, before the labor arbiter, and is claiming the balance of 8 months. 9 minus 1. So to 1 month, the balance is 8 months. So he's claiming the unexpired portion of his contract of 8 months. As I have said, if Seaman A can prove that he was illegally dismissed before the labor arbiter, proving that he was made to forcibly disembark his vessel, and assuming that he was able to prove the same, as labor arbiter, what will your award be in this case? It is 8 months unexpired portion. Why did you award the same? Because dismissal was illegally effected. That is a requisite before the labor arbiter can award any unexpired portion of an OFW's contract. So that's the key word, the key phrase, illegally dismissed. Okay. Then we go to the case of another seaman, Seaman B. By the way, you denominate seamen as sea-based workers. Okay, they are sea-based workers. Okay, so here is Seaman B. He has a 9 months contract. Okay, 9 months. On or before the 30th day, okay, on their first month here, they were in the port of Rio. Do you know where Rio is? In Rio de Janeiro. Okay. And at that time, there was a Mardi Gras going on. There were gyrations in the street of Rio. You know what's a gyration? I don't know. Maybe moving. Okay. Bellies moving. Okay. Not tuna bellies. Okay. So here, while the ship was being unloaded and loaded with cargoes, Seaman B asked permission that they be in the streets of Rio and participate in the Mardi Gras going on there. And he was with X and Y. Okay, so B, X, and Y, all seamen. Okay. The instruction of the ship captain on this RNR is that they should return within 24 hours to the vessel. Of course, X and Y oblige. They returned within 24 hours. But B was already missing in the streets of Rio, okay, de Janeiro, and he returned after 36 hours. Upon returning to port, he noticed that the vessel, okay, employing him was no longer there. So he counted the dollars in his pocket. It was enough to rent a canoe, okay, with 4 paddles. You know, a canoe with 4 paddles? You can use the 2. After that, you can also use the other 2 in an effort to reach the vessel in the high seas, his vessel. As expected, he was not able to catch the vessel. Okay, he returned back, and he found his way back to the Philippines and filed an action for illegal dismissal with a prayer that he should be paid the unexpired portion of his 8 months overseas employment contract. Where should this be filed? Labor arbiter under Section 10. If you are the labor arbiter here, will be win in your sala? Of course, he will not win, because primarily he was not dismissed by the employer. Okay, he was not dismissed by the ship captain, his employer. Okay, so Seaman B will get nothing. Okay. But when you will be judges and labor arbiters, especially if you will be labor arbiters, be kind to OFWs like Seaman B. So this is how you will word the dispositive portion of your decision. Wherefore, premises considered, judgment is hereby awarded to Seaman B, okay, in 0 sum. Okay. Of course, you have awarded something to, of course, only it was a zero sum. Okay? So that's on the case of Seaman B. Okay. Illustration of both the previous law and the now decision of okay. So we have now OFWC. Okay. OFWC. He is a land-based worker deployed in a place in Tabuk, KSA. If there is a Tabuk in Mountain Province, there is also a Tabuk in KSA. Okay. This worker has a 24 months contract. Okay, 12. Okay. So let's illustrate the old one. Okay. And then later on the new one. Okay. The new case. So here, he started working for 30 days, but work condition is unbearable. The weather condition in Tabuk, KSA is really extremes. On cold days, C is given silk blankets on cold days, okay, and coffee below 0 degrees centigrade. Okay. On hot days, is also given coffee above 100 degrees centigrade. And on hot days, his woolen blanket is 6 inches thick. Okay. So on that basis, and aside from that, every time he's made to enter the gates of the company in Saudi, he has to kneel, carry 10 bags of cement and kneel. Okay. So work condition is unbearable. And he found his way back to the Philippines and filed an action for illegal dismissal. Okay. He was able to prove illegal constructive dismissal. And in this case, under the old paragraph 5, unexpired portion or 3 months, what will be the award? 11 or 3 months, because this is less, and then 12 or 3 months for the unexpired portion. The total award under the old law is 6 months for having been illegally dismissed. But today, under the Gallant Maritime case, so here is 1 month, the balance is 23 months. So if that happened after the Gallant Maritime case, then Seaman OFWC will be entitled to the whole unexpired portion of 23 months, subject again to the condition that he has to prove that he was illegally dismissed by the foreign employer. So you see the difference. Before, even if you prove illegal dismissal under these old cases, under paragraph 5, under the case of Marsaman, okay, and skippers, you are only entitled to a total of 6 months. But under the new decision, one is entitled to 23 months, okay, unexpired portion. Okay. So how was the question framed in last year's bar? Although the case was way beyond the coverage. Okay. Here is OFW applicant A, similar to this. He applied with a local placement agency. He signed the agreement. The agency also signed, representative of the agency. This contract was approved by the POEA. Okay. Then, after approval of the employment contract with the POEA, the foreign employer advised the local agency here that a worker already based there whose contract had expired had already taken the place of this worker who is about to depart and work abroad. In other words, he was not able to depart because somebody, according to the foreign employer, advising the local agency, had taken already his position. Okay. So the question was, under the old law, what will be the award? The contract there was 24 months. Of course, under the old law, only 6 months. Under the new decision, it should be the whole 24 months of the contract. because there was clearly a breach of contract by the foreign employer represented by the local agency. Okay, so the unexpired portion, or 3 months, whichever is less rule, is no longer a good provision under paragraph 5 of section 10. Okay, last two examples so that you're in any angle. Two examiners in labor might collapse simultaneously. Okay. For example, so this is OFWD. He has a 24 months contract. 24-12. Okay? Okay. He is deployed this time to Dammam, KSA. Okay. Kingdom of Saudi Arabia. OFWD began working. So then he's already, this is 30 days, and the 20th day, he began, he is always, okay, remembering, he always thinking of his wife left in the Philippines. So he cannot work, he cannot eat. You know, the wife was only 17 years old when he left, okay? And in a scale of 1 to 10, the wife is 11, okay? So that's why he cannot sleep, cannot eat anymore. And worse, OFW is always imagining his kumpare talking to his wife, the kumari, okay? Do you know what kumari means? Kung maari. Okay, 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 okay. So on that basis, he can no longer work, so that on or before the 30 days, upon his request to the nearest embassy, he was voluntarily repatriated. So there was voluntary repatriation upon the request of this OFWD. Okay. If you are the labor arbiter where this case was filed and is claiming the 23 months unexpired portion of his contract, will he win before your sala? Of course he will not, because there was no illegal dismissal that was perpetrated by the foreign employer. It was at the initiative of OFWD that, okay, he was voluntarily repatriated back to the Philippines. Therefore, no award whatsoever will be extended him by the labor arbiter, simply because there was no illegal dismissal to speak of. Okay. And the last one before we take a short break is the case of OFWD. So OFWE, I should say. Okay. He has a 24 months contract. Okay, 24 months, 12. So OFWD is also based in another place in the Middle East. So he now began to work. And he finished 12 months. Then he began working, continued working, finished 6 months. Then he worked and worked again. He's on the last month. He continued to work. He's now on the last day. And on the last minute, 1 minute to go, he was dismissed by the employer. Okay. So this OFW went back to the Philippines and filed a case for illegal dismissal against the local agency and the foreign employer, and claimed the 1 minute unexpired portion of his contract. Okay. Now, the first two hearings before the labor arbiter are called mandatory conciliation proceedings. The same as pre-trial in the courts. So here, determination of the real parties, the issues, the respective claims, and the possibility of settlement. And if you will be practitioners in the future, include everybody. The local agency plus the foreign employer, all other officers and directors of the agency. Why? Because in the past, there were so many paper victories and cases in the NLRC and the POEA, because only the agency was impleaded therein. So this time you should implead everybody. Okay. In this case, in the first conference, in the case of OFWE, the president of the local agency representing the foreign principal appeared. And when asked by the labor arbiter, do you admit that OFWE was illegally dismissed? Then he admitted, yes, he was illegally dismissed. Okay. So the labor arbiter will now have no difficulty in proving that the dismissal was illegal or not. Okay. So in this case, if you are the labor arbiter, what will your award be? Okay. So the unexpired portion, you will, that's equivalent to $2. Okay. 1 minute equivalent to $2. And as counsel, okay, you're entitled to 10%. Under Article 111 of the Labor Code. This OFW is not in grade, so he awarded you, okay? So he wrote a check for 20 cents, okay? How much? 10%, okay, of attorney's fees, okay? So that's how this Serrano case will apply. Easy for application, and maybe, and we hope that this will be asked. And the last topic, 2 minutes. What is 2 minutes for that 0.0001 to be added to your grade to a lower grade of 72? Okay, 2 minutes more before we take a break. Okay. The nature of the liability of the foreign employer or the local placement agency licensed by the POA with the foreign principal is solidary. Joint and several or solidary. If you had been buying those materials in the Xerox stores there on the left side of San Sebastian, right side of San Sebastian, better discard them because there are decoy notes that points to the liability of the foreign principal and the local agency as subsidiary. So it's joint and several or solidary. Many employers and license agencies here, especially the license agency here, in representation of the foreign employer, often points out that this is unfair. The solidary liability is unfair to them because in most cases of abuse or abuses, they have nothing to do with the foreign employer. So why make them liable on a rape committed by a foreign employer, for example, on a domestic helper there? Okay. So the policy is joint and several liability or solidary. For 2 reasons why the liability is solidary. First one is public policy for the protection of our OFWs. That's the first reason why liability is solidary. And the next one would be on jurisdictional ground. The only way that the labor arbiter or our courts will acquire jurisdiction over the foreign principal is through the local agent, the local agency accredited by the POEA. Okay, so this is the reason of solidary liability, public policy for the protection of our overseas Filipino workers, and at the same time, on jurisdictional ground. The only way that jurisdiction may be acquired over this foreign principal represented by the local agency, by the local agent, is a solidary liability. Okay. Besides, under the Migrant Workers Act, if the liability is not solidary, if the local agency will not sign an undertaking of solidary liability, then the papers of their would-be OFWs will not be processed by the POEA. So liability, once more, is joint and several or solidary. And since we are in solidary liability, there are 2 kinds of solidary liability in Section 10. The first one is local agency vis-a-vis the foreign principal. That's number 1. The next solidary liability is officers and directors of the placement agency solidarily liable with the corporation, if it is a corporate entity, or partners in a partnership given a license by the POA are solidarily liable to the partnership. So that's the second kind of solidarity liability. So what's the other name for solidarity liability? It is joint and several liability. Okay. What time is it, lady? Huh? What? What? I cannot hear. 3:30? 3:05? 3:25. Okay, let's just take a short break. 5 minutes to extend to 10 minutes. You know why I asked you what time is it? My watch is only one pointer. It pointed to you. Okay. Okay, what time is it? Okay. Okay. Okay, I'll see you later.
Go to Book 3. What's the difference between pre-employment and post-employment cases? Okay. Prior to 15 July 1995, the POA had both jurisdiction on pre-employment as well as versus post-employment cases or money claims. So, Section 10 of the Migrant Workers Act transferred to the labor arbiter the jurisdiction on money claims, okay, beginning July 15, 1995. But POA retained jurisdiction over pre-employment cases, or what is known as recruitment violation cases or administrative cases committed by placement agencies. So what is a pre-employment case? A pre-employment case is also known as a recruitment violation case. Why a recruitment violation case? Because these are violations by licensed recruitment agencies in relation to the terms and conditions for the issuance of the license or authority. Having violated the same, it may also be denominated as administrative cases committed by placement agencies. Okay. The POEA still retains jurisdiction over disciplinary action cases on OFWs. And for airing OFWs, they are on a watch list by the POA, and likewise, violation of the foreign employers are part of those within the jurisdiction of the POA administrator. So these are pre-employment cases. On post-employment cases or money claims, the labor arbiter has jurisdiction over any breach on the OFW contract, breach of contracts. And likewise, for refund of placement fees collected by agencies plus 12% interest per annum until paid. The labor arbiter has also the mandate to award damages, whether this is actual, moral, and exemplary damages and other forms of damages, including employees' compensation cases. And if you will be asked, what should be the what will be the award and employees' compensation cases filed by OFWs? Supposing in the place where he is employed is providing better overseas, providing better employees' compensation benefits compared to the Philippines. The rule is the place or the country that gives a higher employees' compensation, okay, will be the basis of the award of the labor arbiter. Okay. Example of pre-employment case. A beautiful lady applicant was promised a job in Japan, okay, during the heydays of the Jabayukis. But instead, she landed in a place in Nueva Ecija. It's now a city. She landed in Gapan. Okay, so that's a pre-employment case, okay, a pre-employment case. Another topic that I'd like to discuss would be on escrow agreement. One of the conditions for the issuance of a license or authority is an escrow execution of an escrow agreement where an escrow amount of 1 million is to be deposited in a bank. Okay. The three signatories to this escrow agreement. Don't forget the word authorized when describing these authorized signatories. So this escrow amount is required to an applicant agency as one of the requisites, major requisites for the issuance of the license. Or an agency is renewing its license, an escrow amount of 1 million is required to be deposited in a bank. So who are the signatories to this agreement? There are three.
authorized signatory of the bank where the 1 million is to be deposited, authorized signatory of the POEA, and the authorized signatory of the applicant agency or renewing agency. So 3 signatories to an escrow agreement where a 1 million escrow amount is to be deposited in a bank. Okay. There are only 2 possible questions. Either one of these will be asked on the escrow amount. Question: may a local employee of a placement agency, let's say a placement agency, and assuming that the labor case filed by this local base, let's say an accounting clerk of a placement agency won a case, she's not an OFW, for 300,000. She now is armed with a writ of execution following a motion for the issuance of a writ of execution filed before the labor arbiter, and the sheriff is now with her going after this 1 million escrow amount. Is this reachable by that writ of execution, garnishment, or levy? The answer is no. The reason is this 1 million escrow amount is specifically earmarked for would-be liabilities only to OFWs who will have claims against the agency in the future. So this is not reachable by a writ of execution of a local employee of this placement agency. Similarly, a judgment creditor, let's say the placement agency, B placement agency, bought 10 air conditioners, and a judgment creditor won a case and it's now final and executory, let's say it's 400,000. Okay, may that judgment creditor go against this escrow amount for garnishment and levy thereof? The answer is no. Again, the reason is this is specifically reserved to would-be liabilities to OFWs deployed by this particular agency. So that's escrow agreement and an escrow amount. Then another topic would be the difference between a name hire versus a direct hire. So in a problem, this may be asked: direct hiring and name hiring. Okay. Direct hiring, okay, that's not right anymore. Okay, versus name hire. Okay, is direct hiring allowed in this jurisdiction? Okay, as a general rule, direct hiring is not allowed. Why? For 2 reasons. For the would-be employer, that foreign employer is not assured that he is recruiting a would-be OFW armed with the necessary skills, okay, that he needs. On the other hand, for the would-be OFW, say she is not assured that she will be getting the best terms and conditions of employment abroad. That's why, as a general rule, direct hiring is not allowed. However, the exceptions are as follows. Hiring by the diplomatic corps, hiring by international agencies, deployment of workers on a government-to-government basis through the POA, and lastly, those employers specifically allowed by the Secretary of Labor to hire directly. On the other hand, who is a name hire? Name hire. Why? Can you really hire a name? Okay, so name hire. One who was able to obtain a foreign employment contract through his or her own effort without the assistance of a placement agency. Without the assistance of a placement agency. However, this foreign employment contract must be authenticated by our labat abroad, or our labor attaché, where the work the would-be workplace is located, or by a consul, okay, based in that country. For what purpose? To determine whether the job is an existent job or not. Then this contract now will have to be processed by the POAA. Certain fees will be paid by this would-be OFW and name hire. Thereby, this OFW will now be considered as a documented worker and is entitled to protection by the OWA, the Overseas Welfare Workers and Welfare Administration, and the POAA. Okay. The process by which this name hire is deployed is name hiring. It's an allowed mode of deployment of overseas workers abroad. Okay. Next topic would be on prescriptive period of illegal recruitment cases. Prescriptive period of illegal recruitment cases. Simple illegal recruitment prescribes in 5 years, reckoned from the accrual or the date of recruitment. Accrual. Then those amounting to economic sabotage, large scale as well as syndicated, it prescribes reckoned from accrual in 20 years. 20 years prescriptive period. Okay. Now I would advise you that part of your notes would be listing the requisites for an application for a license with the POAA. Among those would be clearances, then proof of capability to deploy overseas workers, but most importantly, the escrow amount, the escrow agreement, and the undertaking for solidary liability. Okay. So those are important things on overseas employment, but one thing before we leave, if we haven't taken things, we will go back tomorrow. May travel agents, okay, owners of travel agencies apply for a license with the POAA. Okay, this is the general principles that you should not forget. On the application for license or participation in the manpower export industry and the deployment of workers. So those officers and directors of travel agencies are disqualified from being extended a license by the POA. So officers and directors of a placement agency. Okay, let's go to specific examples. A holds 1% share of stock in a travel agency. She is not an officer. She is not a director of the travel agency. Is she disqualified from applying for a license? The answer is no, she is not. Okay? She being not an officer or a director of the travel agency. Okay? Anyway, she only holds 1% share. Okay. How about an officer of a travel agency? Okay, disqualified. How about a director of a travel agency? Disqualified. Oh, here is Miss B. She holds 51% of the voting shares of stock of a travel agency. She is not an officer. She is not a director. Is she disqualified from applying for a license? Okay, that may be the problem that will be asked. Miss B is in control of the majority of the voting shares of stock. Has indirect control. She may appoint who the officers would be, who the directors would be based on his 51% shareholdings. Okay, so she is disqualified. although she is not an officer or director of the travel agency. She is disqualified from being extended or apply for a license with the POEA. Okay. On apprentices, learners and handicapped workers, as well as non-resident aliens, this could be a 5 minutes discussion, but we're reserving it for tomorrow. Let's go immediately to Book 3, where you will expect about 30% of the bar exams. 30%. Book 3, the law and working conditions. Book 3 is also known as labor standards. Okay. The first provision, so you will have various notes as you will be taking the bar on the first Sundays, the first, second, third, and fourth Sundays of September. The notes that you are now taking down are called pre-bar notes. During pre-week, you will also have pre-week notes. And then those very important notes will be the pre-day notes. And between 1 and 2 in the afternoon of the first Sunday of September, you call that pre-hour notes. Okay, so you will have a pre-hour notes before the bar exams starts on in the afternoon. Okay. So we start with Article 82. Your notes should contain coverage. You are covered by the law and hours of work, and then on the other side would be the exceptions. Okay. Now let's go to a bar item. Mark Article 83 in your book. Article 83 in your book. Why? Because Article 83 will answer the question, what is the normal hours of work? And then Article 83 likewise is the answer to a question. Are part-timers allowed in this country or allowed in this jurisdiction? And then the next part would be, what's the work hours of health personnel? Okay, there's a standard in Article 83. Okay, let's now answer the first question. What is the normal hours of work? There is an important phrase that you should not forget, that the normal hours of work shall not exceed 8 hours. It is this same phrase that is the statutory basis for part-time work in this country. Okay. And the other basis would be the second to the last paragraph of Article 124 of the Labor Code. This is the provision on wage distortion. But second to the last paragraph, aside from the phrase shall not exceed, which is the statutory basis for part-time work in this country, in the second to the last paragraph of 124, it provides there that those working for less than 8 hours shall be proportionately be paid for working below the normal hours of work. Those are the two bases for part-time work in this country. So the examiner will proceed. So the normal hours of work, as you will be answering the question, shall not exceed 8 hours. Supposing the phrase shall not exceed is now deleted from Article 83, and the provision will read, will be worded in this wise. The normal hours of work shall be 8 hours. Do you think part-timers will still be allowed to work in this country? The answer is no, because when you say the normal work hours shall be 8 hours, the lowest number of hours, the period to work would be 8 hours. So this is to emphasize the importance of the phrase, shall not exceed 8 hours. Okay. Now, the other portion of this provision is on health personnel. And there is a standard that is set for the work hours of health personnel. If you encounter in your readings in Book 3 and other social legislation, the phrases or the words shall not exceed, at least, not less than, not more than, these are indicative of standards, okay? So let's now go to the work hours of health personnel. There is a disjunctive word, or, to describe, okay, or to describe these standards. So this is a disjunctive word, compliance of the left side standard or compliance of the right side standard, either compliance, ideals both, then the work hours of the health personnel would be 40 hours per week. 8 times 5. 40. Okay, what is the standard? There is, in this particular locality, at least 1 million population. So that's the population. When you say at least 1 million, it does not go below 1 million. Okay. Or there is a bed capacity, there is a hospital or a clinic in this locality with a bed capacity of at least 100 bed capacity clinic or hospital. Compliance of this standard of 100 million population, this 100 bed capacity need not be complied with. Okay, let's give an example on this. So here is a locality where you have a 1.5 million population or a 75 bed capacity hospital. Since there is a compliance of the 1 million, at least 1 million population, the work hours in this locality is 40. In another locality, the population is 750K. You know what, 750,000. But there is a very big hospital in this locality with 150 bed capacity. Okay? So compliance of the bed capacity standard, the work hours will still be 40. Okay. Number 3, there's a certain locality. In this locality, the population is 999,999, short of 1. Okay, or a clinic with 50 bed capacity, a hospital with 50 bed capacity. Okay. Is the work hours here 40 hours? The answer is no. It's more than 40 hours. Okay. But one of those in the 9 is pregnant. Do you know how a pregnant woman looks? Like this. Okay. And in 1 week's time, this pregnant woman, this will give birth. 1 week came, plus 1. You see the historical role of this baby. Okay. So the work hours here in this locality now is 40 hours. Okay. So here is the pregnant woman. This is the baby coming out from her. This is one that defies mathematics. 1 minus 1, okay, equals 2. Okay, so so the giving of birth defies mathematics. Okay. So the fourth example here would be population in this locality, 750,000. Another locality. Or a clinic or a hospital with 99 beds for adults and 1/2 bed for a child. Okay. What's the, it's like 99.5. Okay. Is it 99.5? Okay. The test is actual bed capacity. So here, this is still 100. And therefore, work hours is 40. Okay? And lastly, another example here would be 1.5 million population. Okay. But in this locality, there is no hospital or clinic. Okay, tell me, what's the health hours of the work hours of the health personnel in this locality. Huh? It is still 40, but there is no claimant because there is no personnel in this locality. But the moment a clinic is put up here or a hospital, their hours of work would be 40 hours per week. Okay. Now, on the basis of the examples on the board, there was one case, you can find this in the Green Book of Mr. Susana, the case of the San Juan de Dios Employees Association, San Juan de Dios Hospital, versus NLRC. Here, former Secretary Franklin de Rolon issued policy instruction number 54 to the effect that if the health personnel would be covered by the 40 hours per week or 5 days times 8 work hours per week, they're entitled to 2 additional days, which shall be compensated even if not worked. Okay, so this case reached the Supreme Court. The Supreme Court ruled that this issuance of former Secretary de Rolon, now Senator de Rolon, okay, was an ultra vires issuance, was in excess of his rule-making power, because now it's Article 83 that governs the work hours of health personnel. There's no law that provides that if 5 days are worked under the 40-hour per week scheme, there will be 2 additional days to be paid days. Okay, that was thrown out by the Supreme Court in San Juan de Dios Employees Association case. Okay. Another item in this very important Article 83 is on the question, may a health personnel under this 40 hours per week, okay, working condition, so that this health personnel, can they be compelled to work on the 6th day? Okay, as a general rule, again, as we have said, you cannot compel against the employee's will to work overtime. You cannot also compel the employee, as a general rule, to work on his rest day or on special days or regular holidays. So here, can you compel the employee, the health personnel, to work on the 6th day? Okay. Plural is used in this provision. So in case of exigencies, plural. In other words, you have to wait for an earthquake, a volcanic eruption, as well as flood before you can make this employee, okay, work on the 6th day, because plural is, okay, submittedly, even if one exigency exists, that personnel, health personnel, can be compelled to work on the 6th day. But, again, concept of premium pay. If this health personnel will be made to work on the 6th day, she is entitled to her regular wage plus an additional 30% for the first 8 hours. This 30% of regular wage is the premium pay on the 6th day. Again, what's the premium pay? It's a day that one is not supposed to work. But having been made to work, she's entitled to an additional compensation for the first 8 hours of 30% of the regular wage. That 30% is known as a premium pay. Okay. So that's on Article 83. It's a very important provision. Okay. And the next provision, Article 84, whether one is considered to be at work. So Article 84 is an hour's work. So 4 important phrases or words should be internalized by you so that this will be hours work. Okay. Number 1, when one is required to be on duty or in a prescribed workplace, okay, one is at work. The next would be one is made to suffer or permitted, suffered or permitted to work. All these are indicative that one is at work. Okay. Supposing a professor employed by this school, okay, professor, an employee, is made to hang at the back of this window. And while hanging at the back of that window, in that window outside, he will be lecturing to students inside the classroom. Is he working? Okay, that is his prescribed workplace. Okay. Supposing in a ballet school along Quezon Avenue, there's a ballet school, it's a 6-story building, and on the side of the building would be spires. You know spires? Like the spires here? This pointed portion of a building. Suppose one of the models there would be made to tiptoe in one of those spires from 8 to 12 and from 1 to 5, overlooking. So for 8 hours, you will be displayed there, tiptoeing. Okay. Is she working? Yes, that is her prescribed workplace. Even if there is a danger of falling in front of Quezon Avenue. Supposing in a bed manufacturing firm, the employee, one of the model employees, or one employee who's a model, is required to be sleeping on top of a display bed, okay, 8 hours, okay. Is she working? Of course, that is her prescribed workplace. Will your answer be the same? If this is the bed and the workplace of the employee is under the bed, modeling, okay, you cannot see her anymore, okay, because she is below the bed, okay. So one is required to be to be on duty at a prescribed workplace. One is made to suffer or permitted to work. That is hours work. Okay. Okay. What are items that I would like to emphasize? Don't worry, we have all the time in this world to discuss the others later. I'd like you to take note of the following. One question that is answerable by 4 provisions. And this is a very important question. In what form, where, when, and to whom should wages be paid? So I'll write it for the purpose. I'll write it for the purpose of those who are taping and for the purpose of the tape recorder. Okay. Okay. So, in what form? Okay. So that's the first question. In what form, where, when, and to whom should wages be paid? When and to whom? Okay. Answerable by Articles 102 to 105. Don't forget these provisions, 102 to 105. Okay, let's answer first the question, in what form should wages be paid? Only in legal tender. Okay? That's the general mode of payment of wages. Legal tender, whether in peso bills or in coins. That's legal tender. Okay. What are prohibited forms of payment of wages or salaries? One cannot be paid through a promissory note. Okay. One cannot be paid through tickets. Okay. One cannot be paid through coupons, as well as cheats. Okay. So, you know what's a cheat? So cheats are not allowed. Especially if the employer will pay the male employees cheats. What do you mean by cheats? 2 conchitas. Okay, so prohibited form of payment of wages. Cheats are not allowed. And especially tokens. So for casino habitués, you know, what's a token? Okay. So that is also a prohibited form of payment of wages or salaries. So that you will not forget token, I will define it for you. What's a token? He's a reviewee who is always sleepy or sleeping. Untoken. Okay. Okay. You will never forget. Token as a prohibited form of payment of wages. Okay? So, the next, where should wages be paid? Where? Okay. Then the key phrase here is at or near the place of undertaking or the premises of the company. At or near. Okay. So the cashier, upon having read this provision in the code ranging from 102 to 105, okay, saw a flagpole in front of the company premises, got a knapsack, put the money at her back, payroll on the right side, and then ball pen on the left hand. Then she began climbing, okay, the flagpole. And anyone who would like to be paid should climb the flagpole. Okay. Is that at or near the place of undertaking? Definitely it is, but that is not a practical way of paying the salaries and wages of the employees. Imagine the transaction is on top of a flagpole. Okay. And then, when should wages be paid? Frequency. The standard is twice a month, not exceeding 16-day interval of 16 days and then 16 days. That's the standard. But supposing the employer pays its employees once a month, is that a violation of the standard? The answer is yes. Because the standard is twice a month, 16th and at the end of the month. But the only exception here would be household helpers. They may be paid once a month. Okay. Now, is it within the standard if the employer will shorten this twice a month payment scheme? So here's an employer. He passed by a warehouse owned by the company, and he found payrolls, mountain of payrolls in the warehouse. So he now wanted to change the payment scheme to weekly. Is that within the standard? Of course it is within the standard. This time, with more payrolls around, and the employee would like to consume the same, he now changed from weekly to daily. Is that within the standard? The answer is yes. With plentiful of payrolls still left, he would now change it from weekly, daily to hourly. Is that within the standard? Of course it is. This time he wants to consume the other payrolls left. He now changes payment from hourly to minute. Every minute an employee is paid. Is that within the standard? Of course it is. This time, not content, the employer say, let's pay our employees by the second. So every movement of the employee, pay. Okay. Is that within the standard? Is that within the... Okay, is that within the standard? Yes. Employer not content. We still have many payrolls. Let's now change the per second payment of wages to millisecond. Is that within the standard? The answer is yes. But the last four would be impractical ways of paying salaries and wages. Okay? And subject to certain exceptions. And lastly, 105, this would be, to whom should wages be paid? As a general rule, directly to the worker or to the employee. In case there are reasons that the salaries or wages of the employee or worker cannot be received directly, he may authorize anyone belonging to the members of the family of the worker or employee concerned. Okay. Supposing a worker dies and he leaves an unpaid wages of 10 pesos. So 10 pesos. But he left a widow with 9 minor children as a requirement to attest to the relationship of the widow and the 9 minor children. In order to collect that 10 pesos unpaid by the company, just to execute an affidavit, where in the process, she will spend 100 pesos. Okay. But she insists that you be the lawyer. Okay. And successfully, as you did, you were able to collect the 10 pesos unpaid wages of the deceased worker. The widow was not ungrateful, so he awarded to you 10% of 10 pesos based on a straight line method. The straight line method in computing attorney's fees in 111 is 10 pesos times 10%. That is 1 peso. Okay. So you have received an attorney's fees in a successful case. Okay. You were successful in the recovery of 10 pesos. That is still a success, mind you. Okay. Your attorney's fees there is 1 peso. Okay. So that's on 105. There is no need for an intestate succession in case of the death or of a worker or an employee. So 102 to 105 should be internalized, should be read at least twice before the bar exams. Okay. In what form, where, when, and to whom should wages be paid? Okay, the next discussion is from 106 to 109, and this will be your handy tool to answer questions on labor-only contracting versus job or independent contracting. Traditionally, in the last 12 or 13 years, each year, a question was asked on independent contracting or labor-only contracting on the basis of provisions beginning from Articles 106 to 109. This could be a handy tool for your pre-week notes, okay, and a summary of almost 200 cases plus, 200 cases. Okay, so the next topic will be 106 to 109. So here are facts that may be given by the examiner, and would like you to answer the problem on whether or not the labor supplier is a labor-only contractor, which is prohibited, labor-only contracting being a prohibited activity, or a job or independent contractor. So we go to the board once more, but before we go to the board, please mark these provisions, because if no question will be asked, and 106 to 109, like questions on strikes and lockouts, the possibility of the bar exams postponed or indefinitely transferred will be very great. So mark 106 to 109 in your book, including 263, 264, and 265, and strikes and lockouts, which we'll be discussing in a few hours to come. Okay. So let's go now to the board once more, and please note that this is a summary of 200 cases. And in relation to the issues raised in these cases, and in relation to bar questions asked in previous bar exams. This is how it works, okay? So here is a question. Whether, okay. Labor-only contracting versus job or independent contracting. So the examiner will give you facts, and here is a labor supplier. The examiner Would open this problem with a labor supplier. Classic example is ABC Corporation. Supplying workers and employees. Where? To XYZ Corporation. With this bare facts on the board, is there a basis to conclude that the labor supplier is a labor-only contractor or a job or independent contractor? The facts are insufficient at this point in time. It's insufficient. So let's add some facts. The paid-up capital of ABC is 25,000 pesos. And then there is no indication in this problem that there is investment in terms of tools or equipment. And XYZ is a garments factory. And the workers and employees supplied are as follows. Tailors. You know who is a tailor? Tailors. Sewers. Okay. And peeping toms. You know what peeping toms? Manlililip. Okay. Okay. So, manlililips. Okay. They do the seams of clothes. Okay. Can we now answer the problem? Okay. With the facts on the board, is the labor supplier a labor-only contractor or a job or independent contractor? Okay, let's apply two tests. This will be your handy tool in determining whether the labor supplier is a labor-only contractor or a job or independent contractor. But before we begin to write, if these two tests will be successfully passed by the labor supplier, okay, then independent contractor. Your conclusion is the labor supplier is an independent contractor, but if any one of these tests, as we will see in this example, okay, will not be passed by ABC Corporation, then it is a labor-only contractor. Again, if those two tests will be passed by, successfully be hurdled by the labor supplier, then the labor supplier is a job or independent contractor. But if any one of these tests, cannot be hurdled or will not be hurdled by the labor supplier, then the conclusion is labor-only contracting exists. Okay. The first test, the job and functions of the sewers, tailors, and these manlililips, the very phrase used by 106, are their functions directly related to the main line of business, main line of the garments factory? Okay. It's obvious, isn't it? The answer is not obvious, not only obvious, it is also apparent. Okay. So we will put a check. Pass. Okay. And then the most important test would be the substantial investment test. Okay. In terms of substantial investment, is there a substantial investment in terms of capital? Okay. And the disjunctive word again here is or. Temp. What's temp? This is not temptation. This is tools, equipment, machineries, and work premises. That's the meaning of temp. Tools, equipment, machineries, or work premises. Remember the disjunctive word is or. So compliance with the temp requirement is sufficient, or the substantial investment in terms of capital. In this problem, there is no temp that we have placed in the problem. Okay, let's now analyze. Is a 25,000 paid-up capital a substantial investment in terms of capital? Is it a substantial investment? Okay, the answer is no, it is not a substantial capital investment. Therefore, the second test was failed by ABC, failed the second test. And so with this conclusion, the supplier is a labor-only contractor. By the way, labor-only contracting is a prohibited activity. It is not legal, while job or independent contracting is a permitted legal activity by the dole. Okay, how were the issues in this more than 200 cases resolved? What are the issues? Okay. What are the issues? Okay. Number one, because you have concluded, and we have concluded, that the labor supplier is a labor-only contractor, the first question, or the sequel of questions always asked in cases and also in the bar, with the number one question: who's the real employer of the workers and employees supplied in a labor-only contracting relationship? Again, the question is, who's the real employer of the tailors, sewers, and manlilips deployed to the garments factory? The presidential case in here, the very first case, would be the case of the Philippine Bank of Communications, followed by a coterie of cases thereafter. Philippine Bank versus Orpiada et al. Okay. So the Supreme Court answered in this wise: in a labor-only contracting relationship, the real employer, okay, is XYZ Corporation. Don't forget the reason in the PBCom case. The Supreme Court ruled that in a labor-only contracting relationship, the real employer is the entity where the workers and employees supplied for a comprehensive purpose, for all legal intents and purposes, and by operation of law. Three reasons. Okay, so again, Supreme Court ruled that finding a labor-only contracting relationship, the entity where the workers are supplied for a comprehensive purpose, for all intents and purposes, and by operation of law, it is the employer of the tailors, sewers, and manlilips. Then second question: what then is the relationship of ABC Corporation, okay, and XYZ? What's the nature of the relationship? ABC is merely 007. Do you know what's 007? Agent. Okay. But do not answer 007 in the bar. Okay. So ABC is merely an agent of the garments factory. Okay. Third question, based on all these cases, in a labor-only contracting relationship, who determines the means and manner by which the job and function of the workers and employees, okay, who determines are performed? It is XYZ. When you encounter the phrase means and manner, this is none other than the power of control. So, in other words, let's rephrase the problem. Who determines the means and manner of doing the job by these workers and employees? Or who wields the power of control in a labor-only contracting relationship? It's XYZ Corporation. So, means and manner, XYZ. And its other interests, you have encountered this phrase already in your readings. It's also interested in the end result of the work performed by the tailors and the manlilips in the example on the board. So that's on labor-only contracting. ABC is merely an agent. Okay. Now, please take note of this variation. We said that 25,000 is not a sufficient capital investment. Okay. In 1993, in the case of Neri versus NLRC, good up to this very day, in this case, there was an investment of capital paid up of at least 1 million. Okay. But there is no indication as to temp. So the Supreme Court had an occasion to rule. With a 1 million paid up capital in Neri versus Enalasi, the Supreme Court ruled that this labor supplier is an independent or job contractor. And then the other party questioned, but you have not shown any investment in terms of temp. Supreme Court ruled, because of the disjunctive word or, there is no need to comply with the temp. If the temp is complied with, no need to comply with the 1 million. Okay, in this case, there is no indication of temp. This labor supplier was ruled to be an independent or job contractor. Then of late came a case, the Philippine Fuji Xerox Corporation case. Okay, mid-2000. Now in this case, a labor supplier was supplying Fuji Xerox, Philippine Fuji Xerox, with personnel doing Xeroxing and photocopying jobs. Okay. The labor supplier did not want to lose Philippine Fuji Xerox as a client. So this labor supplier claimed, we are an independent or job contractor. Okay. But the lower tribunals here ruled that the labor supplier is a labor-only contractor. Okay. Now, in an attempt, okay, labor-only contractor, and then labor supplier said, we are citing the Neri case that had a 1 million paid-up capital, so investment in terms of capital. But this time, we have tools, equipment, machineries or work premises worth more than 4 million. Therefore, the labor supplier argues, our company is a job or independent contractor. Okay. Do you think the Supreme Court believed the arguments of this labor supplier? Supreme Court ruled, you are still a labor-only contractor as a labor supplier. Why? Because this alleged tools, equipment that you have, vehicles, were not actually used by this personnel doing photocopying or Xeroxing job in Philippine Fuji Xerox. Therefore, your citation of the Neri case of a 1 million paid-up capital is misplaced. Conclusion of the Supreme Court, you are the labor supplier is a labor-only contractor. Therefore, the real employees of the personnel deployed by this labor-only contractor is Philippine Fuji Xerox. So there is a difference of the Neri case because it referred to the 1 million paid-up capital in relation to the Philippine Fuji Xerox case. What was cited here is substantial investment in terms of tools, equipment, machineries, and work premises. True, they were able to prove that they have 4 million investment, but the Supreme Court ruled, are these vehicles, are this equipment being used by the personnel that you have deployed in Philippine Fuji Xerox? So, conclusion of the Supreme Court, the labor supplier is a labor-only contractor, and therefore, the real employer of the photocopying personnel deployed by the labor supplier, as well as those in charge of Xeroxing, is Philippine Fuji Xerox Corporation. Okay. So that's on labor-only contracting. Then we go now to the other side, independent or job contracting. Okay. So you will exactly see how the cases were decided by the Supreme Court and as in the bar previously. Okay. So we will illustrate two. So here is You know, if you hold the mic tightly, it will not work. How does a lady hold a mic? Like this. Okay. How about a married woman? Like this. How about a widow? Like this. Okay. Okay. I've said mic. I am not referring to anything malicious. Okay. So here is independent or job contracting. Okay. I will give two examples simultaneously of an independent contractor, so that you will appreciate it. Ordinary case, let's say DEF Corporation has a 1 million paid up. Deploys workers and employees where? To LMN Corporation. Similar to this, okay? Okay. And then the next one is a security agency. DMSA deploying security guards, for example, to Allied Bank. Okay. When you encounter this problem in the bar, examiner gives a security agency case, don't attempt to establish, don't apply the two tests anymore. Because as early as the 1970s, the Supreme Court ruled that a security agency is an independent contractor. A janitorial services company supplying janitors and utility personnel is an independent or job contractor. The personnel of an arrastre operator based on Shipside Incorporated, the arrastre operator is an independent or job contractor. Okay, so here is the framework. There is an echo. Echo, okay. Okay. So here we'll ask the same questions. Who is the real employer of the workers and supplied under the first example? Let's say there are also tailors and sewers in a garments factory. In an independent or job contracting relationship, the real employer is DEF. The security guards deployed to Allied Bank, the real employer is DMSA. That's the first question on, or issues raised in these cases. The real employer. Okay. In other words, collateral questions were asked on this. So our conclusion is, when you have established that the labor supplier is an independent contractor, these workers and employees remain to be employees of the independent contractor. The guards remain to be the employees of the security agency. Okay. So that answers the first question. Now, may these workers and employees or the security guards form a union in Allied Bank? No, because the real employer is the MSA. Can the security guards form a union in the MSA? The answer is yes. They are now allowed by law to form, join, and assist in the formation of unions composed of security agencies. Okay, so, and then in a contracting, in an independent or job contracting relationship, who determines the means and manner of doing the job? Who wields the power of control in an independent contracting relationship? Who wields the power of control? Of course, we said DEF is the employer and the MSA is the employer of the security guards. And what is the only interest of LNM Corporation and Allied Bank? End result. In the labor-only contracting relationship, means and manner is with the entities. Here, only the end result. Okay. Okay. Now, next question. How are these agencies or entities paid? Okay, they are paid in lump sum. So DMSA is paid by Allied Bank, for example, by lump sum. What do you mean by lump sum? A certain amount is paid by the bank to the security agency. The security agency, after deducting some amounts as their commission, will now pay the security guards. So the security guards are paid. Okay. So come lump sum number 2. Received by the MSA, but this time it did not pay the guards. Okay. So I will now introduce to you the concept of a direct and indirect employer. DMSA, DF are direct employers, while Allied Bank and LNM are indirect employers. Okay. Now this time, because the guards now were not paid by DMSA, likewise on these lump sums, let's also assume lump sum 1 paid, lump sum 2 not paid. The law based on PBCOM, we have mentioned Philippine Bank of Communications versus Orpiada. In this relationship, in an independent, because of the unpaid salaries of the guards, then the law will consider Allied Bank as if it is the direct employer of the guards for a limited period. So don't forget the phrase, as if. The law considers Allied Bank or LNM as if the direct employer, but this time for a limited period. And what is that limited period? Until the security guards, or in the first example, the workers and employees are paid. Okay. So the guards are now aggrieved, and they now file a case for a sum of money. Okay. So where should the guards file the case? Okay. So question, may the security guards file a case against DMSA alone? The answer is yes. May it also implead Allied Bank? Yes. And what is the reason why Allied Bank can be impleaded in this case? Because the liability is solidary or joint and several. And what is the other reason why? Because it's provided in this provisions on labor-only contracting and job and independent by operation of law. Okay. So you are now confronted with a question. Where should this case be filed by the security guards? Is it before the regular courts, appropriate regular court, or before the labor arbiter? These money claims of the guards have a reasonable causal connection with employer-employee relationship with the MSA. And having a reasonable causal connection of this money claims having a reasonable connection with employer-employee relationship, then labor arbiter has jurisdiction. And why is Allied Bank impleaded? By operation of law. And why is it, what is your other reason why it should be impleaded? Because the liability of the agency and the client is solidary, joint and several. Okay. Allied Bank does not want to have a case, despite payment of lump sum 2, did not want to have a case. So it paid the guards during the conciliation proceedings before the labor arbiter, hence putting an end to this case. Okay. Allied Bank now consults you. Attorney, where will I file the action for reimbursement? So the president of the top officer of Allied Bank, is it before the labor arbiter or the regular court? Okay? So that's the query for this reimbursement. Okay? Then maybe why? You will tell the officer of Allied Bank, is the MSA your employee? Is there an employer-employee relationship between the two of you? Of course there is none. Okay. And what is the nature of the contract? You have answered. It is the nature It's in the nature of a civil law contract. It's a contract for security services. So our first premise is that it cannot be filed. This collection for a sum of money or for reimbursement cannot be filed before the labor arbiter, simply because there's no employer-employee relationship between Allied Bank and DMSA. And besides, the contract they have signed is a contract for the supply of security guards under a contract of security services. Okay, so your advice will be, there being no reasonable causal connection of your claim with employer-employee relationship, this is just a reimbursement, then you have to file this case with the appropriate regular court. Okay. The nature of the liability is solidary. Okay. Okay, one indication based on the many decisions of the Supreme Court that the relationship of DMSA, Security Agency, and Allied Bank would be the purposes for which they are engaged in business. If the purposes, of course, of their business is different, that is one indicator of an independent or job contracting relationship. So let's analyze. What's the business of the security agency? Of course, to furnish security services, investigation services to clients. And what is the main line of business of the bank? Loan intermediation, loan syndication, financing, real estate mortgage. So the purposes for which they exist as business entities, it would be different from each other. Okay. So in this case, this is a very important indication of a job or independent contracting relationship. Okay. So this, in brief, would be your tool, pre-week tool, on any question on labor-only contracting versus job or independent contracting. Okay. So in one case in 2009, decided by one justice who usually lecture in this home, refers to the case of cowboys, so-called, who accompany cattle to be distributed in Luzon from Mindanao. Okay. Company insisted that they were independent contractors because every trip, okay, delivering cattle, their relationship would end, and then they go back and go back, deliver, and then company is of the position that there is no employer-employee relationship simply because they are independent contractors. The good justice found out that there was employer-employee relationship that existed. There was no independent contracting relationship that existed. Indicators, they have no substantial investment in terms of capital or equipment. Okay, therefore they are labor-only, similar to labor-only contracting relationship, but company insists that they are independent contractors, and they deny that these cowboys, so-called, are their employees. Supreme Court found otherwise. There was employer-employee relationship. The defense of the company of independent contracting was thrown out by the Supreme Court. Okay, so on this basis, we will close 106 to 109, okay, but open it during the bar exams, okay? You know, as you study, as bar exams near, as if nothing comes in the mind, that's normal, okay? As if nothing, but the mind is like a computer, that when the time comes, that you would like to retrieve whatever you heard, whatever you have read, whatever you have discussed and debated with your co-reviewees will come out in the bar examination room. That is the concept of stock knowledge. But the spelling of the stock knowledge that I would like to be the correct spelling is S-T-O-C-K. Stock knowledge, when you write, it flows freely and you write and write and write. Stock knowledge. I don't like the other spelling. Stock knowledge, S-T-U-C-K. You write and write and write. The knowledge is stuck in your mind. Nothing is coming out in your ball pen. Okay, so I prefer stock knowledge, S-T-O-C-K. So as I have said, as if nothing is coming inside, okay? That's normal because you still remember that you are forgetting, okay? But the moment you begin forgetting that you are forgetting, oh my God, that's another, that's another thing, okay? And there's still time to talk to yourself silently as you go to pre-week. And ask yourself, why am I doing this? Why am I punishing this myself this much? Why am I wasting resources, time, and even away from my loved ones and one's love? Okay. Why? Okay, and then try to answer yourself. Motivation. Why are you sacrificing? For what? Maybe you will say, for the love of the country. My God, that's the first motivation. Okay. Or maybe you are opting, you are eyeing for a promotion or a vindication of an injustice to your family, to relatives. Those are motivations. But whether any of these motivations brought you here, try to talk to yourself silently at least a minute before you tackle a material. And it will work wonders. Okay. But do not talk to yourself the whole day. Okay? Okay. So, okay. And one last advice. Try to make friends with your enemies at this time. And be very, very holy during this period. Okay? You know what I mean by very holy. Okay? And why make bread with your enemies? For what purpose? You know, if you will not. They will be the first to hit the computer upon release of the bar examination results, even ahead of you, and buy a newspaper at 12 midnight before its release, 1 minute thereafter, in Bulletin and other newspapers, okay? So, and prayer is pray, pray, and pray. God above is the arbiter of all ambitions. Remember that one priest about how many decades ago? 3 decades ago? A priest, if you sum all his grades, he will even be higher than the top-notcher in Diliman. But he was disqualified in taxation. Okay, God did not want him to be a lawyer on that year. The next year, okay, the same message from God. Up to now, he is not yet a lawyer. Okay, maybe God has some designs for him. Okay, so that's on the sideline. Okay, as I see your heads in this review center, you are very stable. You exude stability compared to the other review schools. Every time we discuss new things, their heads will be like waves in the ocean. But in this review center, I see stability and confidence. Okay, that even if the bar will be given tomorrow, okay, okay, I know you will make it. You'll make it. You'll make it. Don't be in any review center next year. Don't be, because the exams next year will be difficult. Multiple choice. Okay. But one choice there is, do you want to become a lawyer? Yes, no, none of the above. Okay, 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 okay. So, don't, that is a difficult question, okay? That will be next year. I hope 60% multiple choice and 40% essay, okay? It's more difficult, okay? Maybe in that exams, the case of reckless imprudence will mount. Why? Maybe those with lack of skill may pass, or lack of foresight. They just answer and answer, okay? So reckless imprudence will make lawyers, okay? Okay, let's go to Article 110, okay? Workers' preference in case of bankruptcy or insolvency. Workers' preference in case of bankruptcy or insolvency. Another probable source of a question in the bar, also asked several times in the past. If you are to read the provisions of Article 110, you will find that beginning 21 March 1989, which is the date of the effectivity of the Herrera-Veloso amendments on the code. So beginning 21 March 1989. Two words were dropped from Article 110 today. The words judicial and declaration. You do not find that anymore in the provision. And it was by virtue of the Herrera-Veloso amendments in the code, Republic Act 6715, okay, that deleted the two words declaration and judicial. Question. Facts first. Previous to 21 March 1989, when the two words were deleted, the Supreme Court, in several cases, ruled that when the workers avail of this ordinary preference under Article 110 of the Labor Code, there must always be a judicial declaration of bankruptcy. There must always be a judicial order of liquidation. That was before 21 March 1989. Then came the deletion of the two terms, declaration and judicial. Did the Supreme Court change its position on the previous pronouncement that it should always be in a judicial declaration of bankruptcy? There must always be a judicial order of liquidation before the workers can assert their rights under 110. Answer. Supreme Court did not change its position, notwithstanding the dropping of the two words judicial and declaration. It is still continued to rule that there is always a need for a judicial declaration of bankruptcy or insolvency, judicial order of liquidation. So that's Article 110. Now, we now go to cases on 110 and application of Article 110. Okay. So one of the items that may be asked on Article 110 would be mortgage credits versus workers' preference. But before we go, okay. This is the principle that you should remember on Article 110. To guide you to answer the correct, okay. Okay, Article 110. The order in Article 110 are as follows. Number 1, worker. Number 2, state. And number 3, other creditors. That's the order in Article 110. And this is what is known as an ordinary preference. Ordinary. Ordinary preference. Where is this? Ordinary. Okay, order of preference. And what is the ideal situation in this order of preference? It means that none of the properties of this bankrupt corporation had been alienated, subject to a real estate mortgage or a chattel mortgage for movables, not subject to any liens or encumbrances. Meaning to say that the properties of the company are free. No mortgages, no encumbrances, no liens. If that is the situation, we can correctly state that workers' preference will be number one over the state and other creditors. That's how the preference is stated in Article 110. But the moment, for example, this company, A Corporation, after it's being declared as bankrupt, the only amount of property left is 5 million. Then state is now asserting its 3 million claim out of 5 million. Okay, so state is claiming 3 million out of 5 million left. So the preference will be like this. State, number one, workers, number two, and then creditor, number three. State was paid. Then the preference will once more be that in Article 110. There is a creditor that surfaced after the state was paid. That creditor will be number one. Then workers and state number three. And after the creditor is paid, then it goes back to the ordinary preference. In Article 110, there is a simultaneous claim. The only remaining asset of the company is 5 million. There is a simultaneous claim of the state for 3 million for unpaid taxes. And a creditor for 1 million. How will the order be? In that case, because both are specially preferred credits, state will be number one, creditor will be number two, and then worker will be number three. Once the 3 million of the state is paid, creditor for 1 million, there is a remaining amount of 1 million that's free. That's the only time that the workers can now be paid for their benefits. In most of the DBP cases that we had been reading and discussing with you, the workers went home without anything because Development Bank got all the proceeds of these mortgages, these alienations, discharged on the properties of the bankrupt business entity or corporation. Okay. Issue. So we always said, always judicial, do not forget that. And that's on the basis of this DBP versus NLRC cases. Now, in one case involving Mr. Peralta and the Republic of the Philippines, in this case, the issue raised was, may the workers assert their claim in an extra judicial proceeding, out-of-court proceeding. Okay. We have already laid the basis that you should always be judicial. But what's the primordial reason why extrajudicial assertion of the workers of their preference under 110 is not allowed? Why? Okay. In this case of Mr. Peralta involving the Republic of the Philippines, the reason was simple. Extrajudicial assertion of this worker's preference cannot be allowed in an extrajudicial proceeding because that would place the state's claim, the government's claim, in a disadvantageous position. The state can only assert its claim in a judicial proceeding, not in an extrajudicial proceeding. That would place again, why is the worker's assertion of their rights under Article 110 not allowed in an extrajudicial proceeding? Okay. Supreme Court ruled that to allow so would place government's or state's claim in a disadvantageous position. Government can only assert this claim in a judicial proceeding. Okay. Last two items before we take a break. Mortgage credit versus workers' preference. Which is superior? So here is mortgage credit and workers' preference. Which is superior? MC, as you just imagine, mortgage credit versus workers' preference. Okay, which is superior? Okay, for your notes. Consistently, in most DBP cases, Supreme Court ruled that mortgage credits are superior to workers' preference under 110. What's a mortgage credit? There are properties of the bankrupt company that were previously mortgaged by way of real estate mortgage for realties or by way of chattel mortgage of movable properties. When this is registered with the Registry of Deeds, it creates real rights. And these real rights are also called mortgage credits. Okay. So on an issue beginning 1989, in the case of DBP versus a labor arbiter, a former colleague in the NLRC, Ariel Santos, which is superior? Mortgage credit or workers' preference? Supreme Court consistently ruled that mortgage credit is superior to workers' preference. Reason? Mortgage credit is a specially preferred credit, and workers' preference, on the one hand, is only an ordinarily preferred credit. So one is special, one is ordinary. Then came succeeding decisions by the Supreme Court beginning 1993. And to the surprise of everybody, this now differentiates the wild reader who will stop in this 1993 case of DBP versus NLRC 1993 circa. But the wide reader will know that a few months thereafter, in February of 1994, the Supreme Court went back to their position that mortgage credit is superior to workers' preference. Okay. So in 1993, so premise, I'm laying down the premise, Supreme Court ruled in several cases that mortgage credit, being a specially preferred credit, okay, is superior to workers' preference under 110. The nature of this claim being only an ordinary preferred credit. Then in 1993, in another DBP versus NLRC case, this time the Supreme Court ruled that workers' preference is superior to mortgage credit, to the surprise of everybody. However, in a few months, because of cases that arose thereafter, on the basis of that ruling, came a 1994 case, good up to this very day. In February of 1994, in Hautea, H-A-U-T-E-A, versus NLRC, the Supreme Court went to its previous ruling beginning 1989 that mortgage credit is still superior to workers' preference. And what did the Supreme Court rule on the previous 1993 case of DBP, where they ruled that workers' preference is superior? Supreme Court ruled what we have stated in the 1993 case of DBP versus NLRC is only an opinion on our part, an obiter. In other words, Supreme Court was telling everyone in the legal community, in the business community, that mortgage credits is still superior to workers' preference, a decision good up to this very day. And lastly, before we take 10 seconds, another question. Did Article 110 of the Labor Code as amended, did that do away with the system of preference of credit under Article 2241 and 2242 of the Civil Code, insofar as preference and concurrence of credits are concerned? Answer is no. Supreme Court ruled that these provisions of the Civil Code and concurrence and preference of credit, Articles 241 and 2241 and 2242, should be read in harmony with Article 110 of the Labor Code, implying that Article 110 of the Labor Code on this ordinary preference of credit did not do away with the system of the preference and concurrence of credit under the Civil Code. Okay, so don't forget, there are two kinds of Article 110 is only ordinary order of preference, while the state's claim as well as other creditors' claim, particularly covered by mortgages, or there's a specific charge on the properties of the bankrupt corporation, are specially preferred credit. Okay, so that if you go to Quezon Avenue, there's a place there, Mamonluk. Okay, there are two kinds of shop house there, ordinary, regular, and special. But whether ordinary or special, every time I go to that place, I see whiskers. What are these whiskers? Okay, you look for yourself. Okay, what are these whiskers? And that place has the most beautiful, most tasteful soup around town. I do not believe that the sacks of the cooks are soaked in the soups there. Okay, so with that note, I'll meet you in 15 minutes. Okay, you take your snacks.
let's continue so we can go home early at 9 o'clock. Okay. So this is Article 110. Please remember that the worker's preference, notwithstanding the book of one author, that whether the properties of the bankrupt company is free or not, the preference still works. But almost all authors and lecturers are of the position that when workers invoke their preference under Article 110, the properties of the corporation, the bankrupt corporation or entity are free from any specific charge or attachment, whether it's a real mortgage, a chattel mortgage, or any other form of encumbrance. It's free. So that one author is of the position that whether it is free or not, okay, the preference in Article 110 still works. That's not very correct. Okay. We proceed first to bar items, and then we go back to benefits and working conditions later on. Okay. So after 110, we have one important item, attorney's fees. Attorney's fees, for the purpose of labor, is the lifeblood of the nation. Okay. So for the purpose of labor. So there is a maximum or a threshold amount of 10% that may be assessed for the recovery, per the provision, for the recovery of unpaid wages or salaries. But even if that is a provision, the Supreme Court, the High Tribunal, in many cases, especially labor cases that pass their level, confirmed the award of attorney's fees even outside of the recovery of unpaid wages. So in the case of heirs of an IBAN, recovery of funeral benefits and attorney's fees was awarded. And then some other awards, not merely limited or confined to recovery of unpaid wages or salaries. Okay. Insofar as attorney's fees are concerned, okay, the assessment thereof should be read in relation to another provision in Book 5. There is a sister provision of 111 in Book 5, and you can zero in on this provision by adding 111 by 111 or 111 times 2. Okay, these are two provisions that should be part of your readings. It must be read at least once or twice before the bar exams, but you read it away. Okay. Before we proceed, I'd like to greet the other reviewees in the other rooms. I cannot see you personally. And anyway, you'll be here up to the bar exams. You haven't bothered to look at your right and your left and said and have said to your seatmates, "Hi." Okay. You would never bother to do that. This is one time to be familiar with each other. You should exactly know the would-be lawyers whom you will be meeting in court. Okay. So for those in the other rooms, good evening. Okay. So attorney's fees in relation to Article 222. Okay. In the case of Traders Royal Bank, where I had a hand in awarding attorney's fees to the union lawyer. So that's Traders Royal Bank versus NLRC. And this is one case for those who would like to top the bar to read. There's still time. Because in Traders Royal Bank versus NLRC, all the conceived kinds of attorney's fees was spelled out in this decision. But traders, here the Supreme Court reduced below 10%, to below 10%, the attorney's fees that I awarded
to the union lawyer. So on the basis of a straight line method, I awarded X amount of award times 10. That's the attorney's fees based on a straight line method. But the Supreme Court, on question of the union, reduced the attorney's fees of their lawyer to below 10% threshold. So below 10%. And what basis did the Supreme Court reduce the attorney's fees of the union lawyer here? On the basis of a legal ethics principle, quantum meruit, as in the bar 3 or 4 years ago. What do you mean by quantum meruit? So attorney's fees may be paid according to the time or the efforts put by the lawyer in a case, and it also depends on the issues as well as his standing. Okay, so it was reduced equitably to below 10%. So when you make reference to a labor arbiter or NLRC division, you say labor arbiter below. Okay, the labor arbiter below ruled that. Okay, and then another impressive phrase would be the labor arbiter ako, AQUO. But in Traders Royal Bank, I would say the labor arbiter ako, spelling AKO. Okay, so here the Supreme Court reduced based on quantum meruit. Okay, so that's only a maximum, but it can be reduced to a lower level, equitable reduction by the labor arbiter, or in this case, by the Supreme Court. Okay. Why did I mention Article 222? Because of the importance of assessment of negotiation fees as well as attorney's fees pursuant to a collective bargaining agreement, okay, where the lawyer actively participated, particularly a union lawyer. Okay, so I'm making reference to one leading case, good up to this very day, the case of Pacific Bank versus Clave. Clave was formerly a presidential assistant heading the legal office in Malacanang. Why Clave is a respondent here? Because before, after the case was decided by the labor arbiter, it goes to the NLRC division, then it goes to the NLRC and bank, which is no longer a procedure. Then it goes to the Office of the Secretary of Labor, no longer an allowed procedure, the deleted procedure. Then it goes to Malacanang. Okay, that's why Clave was a respondent here before it is elevated to the Supreme Court. Okay. So what is the gist of this Pacific Bank versus Clave case? A lawyer cannot compel the union members to pay his attorney's fees. It must yield to a procedure under 241N of the Labor Code. Okay. Don't forget this. 241 is the rights and conditions of union membership, and in 241N will be the assessment of attorney's fees. This is in a form of a special assessment. Okay. And later on, we will compare this to two other related provisions, K, on additional compensation, and the question of major policy. Okay. But if the union members would voluntarily pay, for example, the 10% of the lawyer who was responsible, who was very active in clinching a CBA benefit, okay, then there will be no problem. But if the union members would not pay, does not want to pay, it yields to three procedure requisites. Okay. So what is to be done by attorney X, for example, who's collecting attorney's fees, for example, on a CBA of a 60 million package times 10%, he has 6 million. Okay. So first, there should be a meeting duly called for the purpose. So duly called for the purpose. The main agenda is whether or not the attorney's fees of Mr. X, of Attorney X, should be paid or not. And then majority must approve. Majority authorization. Please take note of majority authorization because this will be useful in other future discussions. Based on total union membership. Okay. What do you mean by total union membership? For example, there are 100 union members. One half of that, 50 plus 1, equals 51. So if in a meeting duly called for the purpose, the vote was as follows: 51, yes, we pay Attorney X, 0, no vote. This is carried because this is based on majority, based on total union membership. Okay? And the third requisite is voting need not be secret. So the voting need not be secret. Okay. So do not place in your papers the word votation. There is no such thing as votation. Okay. Go to your computer, type votation, and there will be a red underlining. Okay. To politicians, this is impressive. Imagine telling to your constituencies, votation. It's a high sounding word. You just say voting. In a voting conducted, okay, that's it. Maybe in the snooker's world, in billiards, there is rotation, but there is no roting. Okay. Okay, so you just simply use the word voting. So these are the requisites. There must be a meeting duly called for the purpose. The payment of attorney's fees must be approved by majority of the union membership, so it's based on total union membership, and voting need not be secret. Supposing 51 appeared in the meeting duly called for the purpose, then 26 voted, yes, we pay the attorney's fees of Attorney X, no, we do not want to pay, 25. Is this carried? No, because this is not based on total majority of total union membership. Okay? So it must be based on the magic number of 51, 50 plus 1. Okay, there's one way, so that you will not forget, of getting the 1/2 plus 1. Okay, this is 100 membership. What do? You have that. Okay, okay. So plus 1 equals 51. Same formula, isn't it? Okay. So 51 is the magic number, based on total union membership. So a number one requisite, which will also be important when we discuss questions of major policy. So what do you mean by meeting duly called for the purpose? The main agenda is whether or not the attorney's fees of Mr. X will be paid or not. Supposing the main agenda is Christmas party in September. Okay, and in other matters, this payment of attorney's fees was discussed. Okay, that is not a meeting duly called for the purpose. Okay, in another instance, maybe this is the collateral question that may be asked. A union president would like to attend the Geneva Conference, the International Labor Organization Conference. Every year, every April, May, or June, there is a conference. So he did not call a meeting for the purpose, but he was able to get 51% plus based on 100 because he is asking for a special assessment for his transportation fares and stipend for the convention. This is an invalid authorization, even if he was able to get majority based on total union membership, because this was not done in a meeting duly called for the purpose, and there was no voting on this. Okay. So after this process, if 51 voted to pay Attorney X, then there will now be a written authorization by the union members authorizing management to deduct the amount due to Attorney X for attorney's fees. So management collects this amount. This is now pooled in the union funds, and it is from the union funds that Attorney X can now withdraw his attorney's fees of 6 million. Believe me, in an actual case, I had a student who just passed the bar 2 years ago. He was on the other side. He was for the union. Exactly on the same figure that you have on the board, he was entitled to 6 million attorney's fees, okay? And when he was able to collect that 6 million, he went to me. I handled management, he handled the union, and said, "Sir, I believe you now. Attorney's fees is the lifeblood of the nation. Could you please come out, sir, and see the fruits of my labor?" Okay. He was sporting a BMW, although this is a 1 Series, that's a black in color, still, with his 6 million, he bought it for 2.1 million, complete with mugs, okay, worth 270,000, okay? So, mag wheels, okay, that's how costly the mag wheels of BMW would be. So, he was able to get 10% based on a straight line method on the CBA benefits that, okay, he got for the union, okay. So 51%, 51, 50 plus 1. Now we go to the 2 items. Anyway, it's related. It may also be a bar item. On 241, rights and conditions of union membership, 241D refers to questions of major policy. On a decision to declare a strike, or to affiliate with a federation, or to disaffiliate, or to form a cooperative within the union is a question of major policy, and it will yield to these requisites. Number 1, 241D. There is a meeting duly called for the purpose, with emphasis on the word duly, then majority authorization, based on total union membership is the requisite, whether to declare a strike or not. And number 3, voting here or balloting here should be secret. That's the difference. Here, in assessment of attorney's fees, voting need not be secret. In questions of major policy, voting should be secret, okay? But it should not be so secret that nobody among the union members knew that you voted, okay? So, balloting should be secret, okay? And K is additional compensation. So, it yields to the same requisites. Meeting duly called for the purpose. Shall there be an increase in the compensation of the officers of the union? And then number 2, based on majority authorization, based on total union membership, and like special assessment, voting need not be secret. Okay. So that's an attorney's fees, okay. And since we are already in Article 222, who may appear before the labor arbiter or the NLRC division? May non-lawyers appear before the NLRC division, before any of the commissioners there, or before labor arbiters? Okay. The answer is yes, if he is the party himself to a labor case, the complainant himself, as the case may be. Number 2, if he is represented by an authorized representative of the union where the complainant is a member. And 3rd, non-lawyers who are members of accredited legal aid clinics. So I'm reminded of a case of late on an issue, whether or not attorney's fees may be awarded to a member, to one belonging to the Office of Legal Aid of UP, okay? May attorney's fees be awarded to that student, member of the Office of Legal Aid. Here the Supreme Court discussed the 2 kinds of attorney's fees. Attorney's fees in its ordinary sense, this is normally awarded to the lawyer who represented the party. In its extraordinary sense, according to the Supreme Court, this is not necessarily awarded to that 4th-year student of the Office of Legal Aid, but it is awarded to the party he is representing in the concept of indemnity, okay? In the concept of indemnity, not really attorney's fees, to the non-lawyer representing that party. So that's an Article 222 of the Labor Code, 222. Then we go to the cluster of provisions from Articles 112 to 119. ending in false reporting. Please take note that all of this from Articles 112 up to 119 are offenses under the Code, including discrimination in Article 135, violation of wage orders, violation of Article 136 on stipulation against marriage and prohibited acts under Article 137. All of these are punishable by Article 288. Why? Because there are two penalties under the Code, 272 and 288. Same penalties in Article 288, same penalties and fines in Article 272. What's the difference? Almost all offenses under the Code is punishable under 288 of the Labor Code, Article 288 of the Labor Code. Violation of wage orders, so 288 of the Labor Code, almost all. How about 272? What is punishable by Article 272 of the Labor Code? It only is confined to violations of Article 264, prohibited acts during a strike, lockouts, and concerted activities. So any violation in relation to a strike, a lockout, or concerted activity, Article 272 will be the penal provision applicable. All other violations, Article 288 will be the penal provision that would be applicable. Okay. So non-interference in the disposal of wages. In brief, all these provisions refers to non-interference in the disposal of wages. The point that I'm driving at is, based on principles and decisions of the Supreme Court, the employer cannot interfere with the salaries or wages of a worker or an employee before it is handed down to the employee concerned. For example, an employer paying monthly Inday A. Okay. Every time Inday A receives her salaries from the employer, she donates it back. So January salary, donates it back to the employer. February, March, April, all donated back to the employer. Came May, employer said, Inday, I know you will donate that salary back to me. I will not give it to you anymore. Okay. A presumption on the part of the employer. That is already a violation. A violation. So in this cluster of provisions, it's important to note lawful deductions. What can lawfully be deducted? For example, premiums advanced by the employer, okay, on an employee, insurance taken by an employee, okay, can be deducted. Withholding of salary, withholding of taxes, withholding taxes, okay, allowed. Withholding deduction of SSS contributions, field health, pag-ibig, and the like. Okay. Lawful debts incurred by the employee, okay, which is already due, can be deducted by the employer, and such other lawful deductions. Okay. There is one notable case of note, which is 5J taxi versus NLRC. There were two issues here raised. The first of which was whether or not it is lawful for the taxi operator to deduct from the earnings of the taxi driver a certain amount. And the purpose is to answer for shortages of boundary in the future. Okay, that was one issue raised. The second issue raised was whether or not the deductions effected by the employer for cleaning the taxi is legal or not. Okay. On the first one, on deduction from the earnings of the workers for the purpose of applying the same on future shortages and boundary, was held to be an unlawful deduction. While the deductions for cleaning the taxi, according to the Supreme Court, is an accepted practice in the trade. So the second one was allowed, the first one was disallowed, okay, as illegal. Okay. And then it is likewise unlawful for the employer to withhold salaries or to receive kickbacks, okay, for the purpose of maintenance of employment or as a condition for continuance of employment. That is prohibited. So that is withholding, or what is known as kickback, okay? So that is not allowed. And also 119, false reporting. So on kickbacks, the examiner will not ask this question. Is kickback a back kick? Okay, so don't forget 116 of the Labor Code as amended, okay? All of these are offenses under the code, okay? Then we go to the bar items. I'm talking of 2 bar items and then another 2 following the first 2. Let's concentrate on this first because the possibility of being asked, okay, is very great. So I'm referring to Article 123 on wage distortion, wage order, I should say, and 124 on wage distortion, and 128, particularly 128B on the visitorial and enforcement power of the Secretary of Labor, and money claims, jurisdiction of the regional director, 129, and 217A6 by the labor arbiter. Okay. So I'm calling your attention that there is Republic Act number 6727. What is Republic Act 6727? Okay, what is the significance of this law? This is the Wage Rationalization Act. And what further is the significance of this law? It created the National Wages and Productivity Commission. It likewise created the regional boards. Okay. So this is Wage Rationalization Act, Republic Act number 6727. Okay. And it created both the National Wages and Productivity Commission and the regional board. Okay. It delegated to the regional board the power of wage fixing, and it is the same law that legislated a bar item, 123, wage order, 124 on wage distortion. Okay. So what's the other significance of this Wage Rationalization Act? Aside from this law creating the National Wages and Productivity Commission and the regional board. Okay. This is the last national minimum wage law passed. That's the other significance of the Wage Rationalization Act. And later on, it will have relevance on the 1-year ban on wage orders to be issued within a year from effectivity. Okay. So let's go now to Article 123. Whenever the conditions in a particular region warrants, after a public hearing conducted with all the stakeholders called, and the requisite publication thereafter of a wage order issued, then comes the effectivity of a wage order. Okay. There is a 1-year ban on wage orders issued by the regional board. There is a 1-year ban. Okay. By the way, what is this regional board? This is the Regional Tripartite Wages and Productivity Board. In brief, is the regional board. That's now the entity that is tasked to fix minimum wages in the region. So there are as many regional boards as there are geographical regions in the country. Okay. Because of the conditions that obtains in several regions, the minimum wage in Metro Manila is slightly higher to minimum wages in Region 3 and in Region 4 and in the Calabar Zone area. So that is dependent on the conditions obtaining in the region. Okay. So what are the possible questions that may be asked by the bar examiner in Article 123? Number one, effectivity of a wage order. Okay. A wage order takes effect 15 days after complete publication. So publication is, there's a word before the word publication, which means complete publication. What's the meaning of complete publication? Where? In a newspaper of general circulation in the region. This is important. Today, since wage orders are not that lengthy, wage order may be issued or maybe only may publish only once. For example, wage order is published 5 January 2010. Okay, so you count 15 days, exclude the first, okay, and it takes effect on the 16th day. Okay, and that is a complete publication. Maybe there in the future there will be lengthy wage orders. So on 5 January, the first part was published, 2010. The second part is 15 January 2010. So it's from the last date of publication, 15 January, that completes the publication. Okay. So that's the meaning of the word complete. Okay. Now, another question that may be called from Article 123. Should the aggrieved employer, by virtue of a wage order issued, should the aggrieved employer wait for the effectivity of the wage order before it can file an appeal? Okay. The answer is very clear on the basis of this provision. An aggrieved employer may file its appeal within 10 days from publication, meaning to say that publication there is also complete publication. In other words, the aggrieved employer, by virtue of a wage order issued by the regional board, need not wait for the effectivity of the wage order in order to file its appeal, because it is given the leeway there to file the appeal within 10 calendar days from publication, meaning complete publication. So there is no need to wait for the effectivity of the wage order before it can file an appeal. Where? The word commission in Article 123 refers to the National Wages and Productivity Commission. So in Article 123, do not confuse this. That the word commission there is that the appeal from wage orders issued by the regional board is appealable to the NLRC. Okay, that commission there in Article 123 refers to the National Wages and Productivity Commission. So that answers the question. Should the aggrieved employer affected by the wage order wait for the effectivity of the wage order before it can file its appeal? Then 123 is instructive of the answer. Next question. Will the mere filing of the appeal from the regional board to the National Wages and Productivity Commission, will that stay the effectivity of mere filing of an appeal? The effectivity of the wage order insofar as that aggrieved appealing employer is concerned? The answer is no. It does not stay, it does not stop the effectivity, unless the appealing employer will file a surety bond or issued by an accredited bonding company by the Commission, meaning to say the National Wages and Productivity Commission. So the mere filing of an appeal will not stay the effectivity of the wage order. Okay. So the power of the regional board is a delegated power from Congress to fix minimum wages, okay, in the various regions. Okay. So that's a delegated power from Congress. Am I pronouncing the word pronouncing regional tripartite wages and productivity commission? Am I pronouncing the word tripartite correctly is not the word pronounced as tripartite. Okay, so it's not. Okay, so don't forget, in brief, the regional board. Okay, so tripartite. So this is a delegated power, and one question that may be expected on this delegated power is the derogation of that power. So there is a ban within a 1-year period from the effectivity of the wage order. So this is the effectivity date of the wage order, which means, say, on the 16th day from complete publication. Okay. So within a 1-year period, the regional board is prohibited to entertain any petition, any request for a wage order that will be issued during the year. This is prohibited. So the general rule is no wage order can be issued by the same regional board within a 1-year period. That's the 1-year ban reckoned from the issuance, from the effectivity of the wage order. Is there an exception? The only exception, okay, in answer to the question, may Congress, being the source of this delegated power to the regional boards to fix minimum wages, may it derogate or may it override this delegated power? The answer is yes. In what way? By passing a new national minimum wage law. This is an exception to the 1-year ban. In general, the regional board is prohibited to issue a wage order during this 1-year period. The only exception is Congress, within this period, passing a law, a national minimum wage law, which in effect is a derogation or an overriding of that delegated power from Congress, delegated to the regional board from Congress. So those are items of note on Article 123. Okay. One notable case in the book of Mr. Azucena, in his Green Book, is the Cagayan Sugar Milling Corporation case, where the Supreme Court nullified a wage order issued by Regional Board Number 2 for reason that it was declared null and void, for reason that there was no public hearing and no requisite publication required under Article 123 of the Labor Code as amended. Okay. So that's on wage orders. We will discuss later on the second mistake of Regional Board Number 2, nullifying again a wage order issued based on the salary floor method. Okay. Let's now proceed to the next provision. As in the bar already consistently by examiners on wage distortion, Article 124 and 123 should be marked in your book. Okay. You know, this is one time that you should begin underlining important portions of your book. In the process, you give justice to your book. But the only colors allowed would be pentel pens colored green, orange, and yellow. The only time I will allow for myself that you underline with a black permanent marker the provisions of your book, okay, is when you have mastered these provisions. Okay, so you can obliterate all the letters in your book when you shall have mastered the same. Okay, but at this point in time, no black permanent marker. Okay, so Article 124. You conceive two position levels in a company. And on the basis of those position levels, the higher position gets a higher salary. The next position level gets a slightly, or there is a gap in the salaries received by the second level employee. So let's go now to an illustration of this. So two levels. Okay. So you are looking at a supervisor, okay? A supervisor in a company, okay? Let's say it's a supervisor A. So this is his position, and for theoretical purposes, he receives 300 pesos, okay? And below her is a senior accounting clerk, okay? A senior accounting clerk with a salary of 280, okay, pesos. So on the basis of this position levels, there is now an intended quantitative difference in money terms, in monetary terms. So the intended quantitative difference is 20 pesos, okay? And by the way, there are two methods by which minimum wages are fixed today by the regional boards. The first one is the salary floor method. Okay, salary floor. So in the salary floor method, all those receiving minimum wage, let's say at 25 pesos is decreed, all minimum wage earners are entitled to this 25 pesos. So the mistake of Regional Board number 2 in one case of recent vintage was that it not only, okay, decreed the 25 for minimum wage owners, it also included all those receiving above minimum wage. That was invalidated by the Supreme Court. Another mistake by Regional Board number 2. So only minimum wage earners are entitled under the salary floor method. So where's the floor in this room? This is the floor, okay? But where is this is also a ceiling if you are in the 4th floor. Okay, so, and the other method is the salary ceiling method. This is the ceiling, otherwise known also as the salary cap method in fixing minimum wages. So where's the cap? The cap is here, isn't it? Where's the ceiling? The ceiling is there, okay? But for Jejemon, the cap is here. Okay, okay. It's right here, okay. Okay, so there is a salary ceiling or salary cap method. Okay, a wage order now is issued by the regional board. How does the salary ceiling method works? So there is now a wage order issued for 25 pesos increase, okay? But all those receiving 290 and above, this is now the cap or the ceiling, are not entitled to the 25 pesos increase. They are covered by the cap. So let's analyze. Is the supervisor covered by the cap? Yes. So he'll still be receiving 300 pesos. How about the senior accounting clerk? She is not covered by the cap. Therefore, she is entitled to the 25 pesos increase. Total, 305. Okay. So here's a situation where the female accounting clerk was then under the supervisor. Now, the senior accounting clerk is now above the supervisor in salary terms. Okay. So, there is now, what happened with this wage order? There is now a total elimination or obliteration of the quantitative difference of 20 pesos. Before you can see it, now you can no longer see it. There is an obliteration of the quantitative difference of 20 pesos. Okay. In one bar exams, a few years, since there is now an distortion on the salary of the supervisor, the bar question was, how do you correct the distortion on the salaries of employees affected by a wage order issued? Okay. So here, Article 124 was the answer to that bar examination question, because Article 124 is instructive on the methods by which correction on distortion on salaries and wages is to be effected. So it all depends whether the supervisor, now your client, okay, It belongs to an organized establishment or an unorganized establishment. Okay. So the supervisor now, Mr. Ray, consults you. You are now a lawyer. Attorney, I have a problem. The supervisor under me is receiving 5 pesos more than what I am currently receiving. Okay, please help me. Please advise me well. Okay. The bad advice is you ask the supervisor to go to Rex bookstore and buy a codal provision of the labor code. Okay, codal labor code, and tell him, read for yourself what is in Article 124 as to your rights and remedies. That is bad advice. Okay, do not do that. So here, your first question to Supervisor A is, do you belong to an organized establishment? Okay. Do you belong to an organized first establishment? And when he says, yes, I belong to an organized establishment, I belong to a supervisors, I am a member of that supervisors union, then your advice will be, tell him to talk to management. So supervisor now will be advised by you to talk to management. Okay. So that's the first step. Supervisor, okay. And then I will instruct the supervisor, if I'm the lawyer, to buy a pentel pen. Okay. 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 So supervisor talks to management. Okay. Management now intends to increase his salary by 10 pesos. And then he consults you back. Attorney, will I accept the 10 pesos? Because this is way back below the 20 pesos historical gap before the wage order. Okay? Then you will tell the supervisor. On the basis of the case of the National Federation of Labor, there is no obligation on the part of the employer to restore the historical gap of 20 pesos. It's enough that there will be a reasonable or significant gap. So that's the gist of the National Federation of Labor case, answering the question whether management, by virtue of a wage order and where a wage distortion arose, is under obligation to restore the historical gap of 20 pesos. Okay. Your answer to Mr. A, supervisor, is that management is not duty-bound to give you that historical gap. It's enough that there is a significant or reasonable gap. In this case, if he accepts it, then he will be getting 310. And then there will again be a reasonable gap of 5 pesos or a significant gap of 5 pesos. But if he does not accept this 10 pesos, the next step would be submission of the case to the grievance machinery. What's the grievance machinery? This is a mandatory provision in all CBAs providing for a machinery for the adjustment of disputes between the union and management. You call that a grievance machinery. And if nothing happens, if it remains unresolved, then it goes to the third step. It goes to a voluntary arbitrator or a panel of voluntary arbitrators. That's the procedure in the correction of distortion on wages and, or salaries in an organized establishment. So within what period? If nothing happens in the grievance machinery, within 7 days, both parties will now sign what is known as a submission agreement, outlining the unresolved issues in the grievance machinery, and thereafter, it will now be referred to a voluntary arbitrator or a panel of voluntary arbitrators if there are more than 2 arbitrators. Okay. I asked one student in near Quiapo, what do you mean by PVA? I asked him. PVA? Sir, that is the League of Basketball Owners. PVA. I was referring to panel of voluntary arbitrators, okay? So that's the procedure for organized establishment. If, on the other hand, Supervisor A will tell you, Attorney, I do not belong to an organized establishment, okay? I am not a union member. Although there is one there, I am not a member, okay? So what are the indications of an unorganized establishment, okay? And the procedure. Number one, unorganized. There may be a legitimate labor organization there. Okay? What do you mean by a legitimate labor organization? It's a labor union or organization registered with the Dole Regional Office. Dole Regional Office. But it is not yet recognized as the exclusive bargaining representatives of the supervisors, for example, in this case. And if there is no recognition yet, there is no CBA to speak of. And if there is no CBA to speak of, there could be no grievance machinery as of yet to correct the distortion of the salaries on the salaries of Mr. A, Supervisor A. Okay, so that's first indication. Or there is a legitimate labor organization in the company, meaning to say this is not registered with the DOL. It's just a loose union, and that's why I said or. Or there is an association of employees in this company. You call this the Association of Silahis Employees. Okay, Silahis dito, Silahis, unorganized. Okay, and the last one is no union at all. So unorganized establishment, no union at all. So if these are any of the indications, then you will advise Mr. Supervisor that this is the first thing that he should do, unorganized. Supervisor is advised to talk to management. Okay? Management adjusts and accepts it. No labor dispute. He does not accept the offer of management. Then he goes to the second stage. File a case with the regional office of the National Conciliation and Mediation Board. Okay. Okay. This principle should be remembered and internalized by you. What is the venue? Where should I file? Okay. In labor cases, it is the workplace of the employees that determines venue and jurisdiction, both venue and jurisdiction, which is region-wide. So that if this company of Mr. A, Supervisor, is located in Valenzuela City, that's within the NCR, the National Capital Region, he can file it with the NCR, Regional Office of the National Conciliation and Mediation Board. Again, even in the NLRC, even in the office of the BLR and other labor offices, it is the workplace of the employees that determine venue and jurisdiction in labor cases, which is region-wide. Okay. So in this case, it's now assigned to a mediator and conciliator, and if nothing happens after 10 days, then it is the labor arbiter. Okay, NCR, let's say Valenzuela, NCR Regional Arbitration Branch of the NLRC, where this case may finally be filed. In other words, add this to your area of jurisdictional conflict. In organized establishments, if S belongs to an organized establishment, it will be the voluntary arbitrator who will be finally be tasked to correct distortion on his salaries. But if the supervisor, Mr. Ray, belongs to an unorganized establishment, it will be the labor arbiter who will finally dispose of his case to correct the distortion on his salary. So there is a distinction. This was the answer to the question about 3 or 4 years ago on procedure on the correction of distortion on salaries or wages. Maybe it will be asked again, but it will be asked in a different fashion, okay, by the examiner. Article 124 of the Labor Code as amended, okay. If you are a wide reader and you are reading the book of Mr. Claudio, He has a reviewer. The cover is blue. He was just copying the provision of Article 124. Instead of quantitative difference, intended quantitative difference, he put the qualitative intended difference. This may unduly confuse you if you are a very wide reader, okay? Sometimes bordering wild, okay? So this is Article 124. Distortion on salaries and wages are not strikeable issues. They are non-strikeable issues. And assuming that the union, okay, let's take note, files a notice of strike on the ground of distortion on salaries and wages of their union members, okay, and where do you file a notice of strike? Okay, the notice of strike is again filed with the regional office of the NCMB. Workplace again is determinative of venue where the notices of strikes and the strike vote report is to be filed. NCMB regional office, okay? And once the notice of strike is assigned to a mediator or conciliator, and it determines that the ground in the notice of strike is a non-strikeable ground, then this is automatically converted into a preventive mediation case. In other words, the effect of the conversion of this non-strikeable issue into a preventive mediation case is as if the notice of strike was withdrawn, as if no notice of strike was filed. And if the union continues to stage an actual strike on the basis of this non-strikeable issue contained in the notice of strike converted into a preventive mediation case, they continue to declare an actual strike. That strike is to be declared an illegal strike. Effect, officers who knowingly declare that illegal strike will lose their employment status. Members will be reinstated, but they are not entitled to back wages or what is known as a strike duration pay. Why were the union members reinstated despite this strike declared illegal? Because of the principle that even if a strike was declared illegal, there is no wholesale dismissal of union members unless they were engaged, they have committed violent acts, okay? There's no wholesale dismissal, okay? So that's on, okay, preventive mediation. So remember this, if in the notice of strike, raised therein would be a non-strikeable issue like the wage distortion, that is automatically converted into a preventive mediation case, the effect of which is as if the notice of strike was withdrawn. And if stubbornly the union will still stage an actual strike on that notice of strike filed, then that strike will be declared as illegal, okay? So in your Absusena book, there is what is known as the Metrobank formula. The Metrobank case where previously the vice chairman of the NLRC was the ponente of that decision. And this is known as the Edna Perez Bonto formula. It's a suggested formula in the correction of distortion on wages or salary. Metropolitan Bank formula. Okay, of note would be one case, the case of the Prudential Bank Employees Association. You call this the Prue Bankers case. And the only issue here, aside from that wage order issued, is whether or not, similar to this, an employee, for example, of Allied Bank, based in Cebu. Okay, so here is employee A of Allied Bank, based in Cebu, and there was a wage order issued in Region 7. So teller A compares her salary now. Okay. Okay. This does not work. Okay, it does not really work. Okay. Okay. So teller A of Allied Bank, based in Region 7, by virtue of a wage order issued, compares her salary with teller B, based in Marikina, Metro Manila. Because of a wage order issued, she's trying to compare. Okay, on the basis of the Prue Bankers case, inter-regional comparison of distortion and salaries to determine whether there's distortion on the salary of A is not allowed. However, A can compare her salary with teller C based in Tagbilaran, Bohol, because Bohol is within Region 7. This is intra-regional comparison, and this is allowed. Okay, that's on wage distortion, Article 128. Okay. So we go now to two important items: the visitorial, inspection, and enforcement power of the Secretary of Labor. I'm referring to Article 128 of the Labor Code. On the other hand, there is also money claims which are within the jurisdiction of the regional director and the labor arbiter. Take this as bar items, and this should be part of your pre-day notes because, again, of their likelihood to be asked in the bar exams. These are two bar items separately. So Article 128. Okay. In your book is still not yet removed in your books would be the case of Servandos Incorporated versus the Secretary of Labor. So here's Article 128 of the Labor Code, Article 128B specifically. The visitorial, enforcement, and inspection powers of the Secretary of Labor. Okay. And the main officer of the DOL is the Secretary of Labor, and this power may be exercised by the regional director, primarily, by the labor employment or enforcement officer, or by a safety officer of the DOL. Okay. So here, the Servandos ruling. What's the Servandos ruling? Okay. Is this ruling still good today? Okay. The answer is obvious. I'm canceling it. Okay. So, it's no longer good today because the Servandos ruling limited to 5,000 the amount subject of inspection. Because in June of 2007, in June of 1994, I should say, came Republic Act 7730. What is this 7730? It's an act that expanded the visitorial, inspection, and enforcement power of the Secretary of Labor. Okay. Now, just to illustrate to you how the Servando ruling worked at that time, supposing there are three complainants, A, B, and C, presently employed. So when workers avail of this provision, this inspection, visitorial, they must be presently be employed. So A, B, and C are presently employed. They are claiming violation of labor standards and other laws. The claim of A is 3,000. The claim of B is 7,000. And the claim of C is 8,000. Under the Servandos ruling, only the case of A is within the jurisdiction of the Secretary of Labor. But when Republic Act number 7730 took effect, it had superseded, okay, in effect, rendered of no force, the Servandos ruling. Because if this case was filed after Republic Act number 7730 was made effective, all these cases are now within the jurisdiction of the Secretary of Labor, exercised through the regional director. So that the ceiling of 5,000 set by the Servandos ruling is no longer a good, this is no longer a good decision. So all of this, based on Republic Act 7730, provided that these employees are presently employed, that is the condition. All of these are now within the jurisdiction of the Secretary of Labor as represented by the regional director. So Secretary of Labor. Now, there is one case of note. We said that employer-employee relationship should exist at the time of the filing of this case. That should be given, And with that, the regional director, since they are presently employed, and as representative of the Secretary of Labor, can now take cognizance of this case. This is an inspection case. This is a visitorial or enforcement power case. This is one case initiated by employees. But there are also inspection cases where in the routine inspection conducted by inspectors of the DOL, or the Labor Employment and Enforcement Officers, they find violations of the company. So that's the other kind of case that is initiated by the DOL's regional office in representation of the Office of the Secretary of Labor. The case on board is an employee or employees, the employees here initiated the complaint. So all of these are now within the jurisdiction of the regional director. Now what happens after this case is filed with the regional director by A, B, and C? These are their claims. The regional director, as representative of the Secretary of Labor, will now issue an inspection order. So regional director, and these are employed by, let's say, A corporation. That's the employer. So the regional director now issues an inspection order. Where? To a Labor, Employment, and Enforcement Officer. What will the LEO do after receipt of the inspection order? He will go to the office of A corporation and will try to ask questions from some employees of A corporation on the claims of A, B, and C. And the LE, or the Labor, Employment, and Enforcement Officer, will also ask some documents to be produced, maybe payrolls in the past, so that on that basis, LEO now will render a report. And supposing his report is a finding that indeed A corporation violated labor standards, This time, the LEO now will prepare a report, one furnished to the regional director, first report, and another report, report number 2, to A corporation. If A corporation will just await for the enforcement order or a writ of execution from the regional director anyway, it will only be liable to about 18,000 pesos claimed by A, B, and C. That will put an end to this inspection order. But imagine a big corporation. The minimum claim for violation of labor standards is, let's say, 3,000, and there are about 3,000 employees. That would mean $9 million bucks. So here is another area of jurisdictional conflict that I am bringing to the fore. It's a jurisdictional conflict between the regional director versus the labor arbiter. And this is now the principle of divestment of jurisdiction of the RD in favor of the labor arbiter, present 3 requisites. So there are 3 requisites before regional director in an inspection case well within his jurisdiction is lost in favor of a labor arbiter. Number one, upon receipt of the report, employer will contest the findings of the LEO. Okay, number one, don't forget that. Number two, there's a need to thresh out evidentiary matters. Okay? And an issue or issues is raised on that there is a need to thresh out evidentiary matters. And number three, these evidentiary matters could not be obtained in the ordinary or routinary course of inspection. I will repeat, these are the requisites for the divestment of jurisdiction by the regional director of a case well within its inspection and visitorial powers. Okay, so one, upon receipt of the company of a corporation, the company subject of inspection, a copy of the report, it will now contest the findings of the labor, employment, and enforcement officer. And number two, the company will raise issue or issues that there is a need to thresh out evidentiary matters. And this evidentiary matters, number three, could not be obtained in the ordinary or routinary course of inspection, not the course of reproduction of these documents. And if all these three requisites on the basis of the only portion in Servandos, cited in Servandos, outlining these three requisites, the case is SKK Parts versus Corporation versus Commerce. Okay. This is the only good. Okay. So don't, even if you are very sure of the case in the bar, don't cite the cases, because the examiner might be hot-headed. Okay. SKK Parts Corporation versus Kamas. He might only see KK Parts versus Lamas. Okay, so don't cite cases. Okay, please. Okay. So in SKK Parts versus Kamas, the only cited case still good in the Servandos ruling would be the three requisites for divestment of a jurisdiction of the regional director in an inspection case well within his jurisdiction in favor of the labor arbiter. So this is the principle of divestment of an inspection case taken cognizance by the regional director in favor of the labor arbiter. Present these three concurring requisites on the basis of SKK Parts Corporation versus Kamas. Okay. So that to your area of jurisdictional conflict. Okay. What is this case of note that I was telling? We started with the premise that when employees avail of Article 128B of the Labor Code, employer-employee relationship should still be existing. Okay. So in that case of note that I said, we can make reference to the case on the board. Let's say there were three complainants who were presently employed then at the time of the filing of this inspection case. A, B, and C were presently employed. But while the regional director is conducting an investigation and still conducting a hearing on this inspection case, A, B, and C were dismissed midstream. In other words, before any action, final action can be had on the inspection or restoral case, enforcement case, A, B, and C were dismissed. Okay. The contention of the company, their employer, is that the regional director lost jurisdiction over this inspection case. Why? Because of the premise that employees should be presently employed, okay, in order that this visitorial powers could be exercised by the regional director. Is the contention of management correct? Okay, Supreme Court ruled in this wise. At the time of the filing of this inspection complaint, employer-employee relationships still existed. True, they were dismissed midstream. But that does not mean that the regional director had lost jurisdiction over this inspection case, because at the time of the filing, regional director had jurisdiction, virtually throwing out the grounds of the employer in this case, that the regional director lost jurisdiction over this inspection case. Okay? Supreme Court ruled, regional director continues to hear this case. So that was the only issue raised there. So notwithstanding the dismissal of the employees midstream while the inspection case is pending, that does not mean loss of jurisdiction by the regional director via their dismissal. Okay? Regional director still continues to have jurisdiction over this inspection case. It was taken out of this case of now. Okay. And we go now to Article 129 in relation to 217A6. These are two provisions that should be part of your pre-week notes. Okay. So Article 129, Article 129 of the Labor Code in relation to be read with 217A6. Okay. So what is this? Jurisdiction on money claims by the regional director, small money claims. And here is the labor arbiter. Okay. Now, as an introduction, in 217A, from 1 to 6, before this is the number 6, jurisdiction of the labor arbiter, there is an accepting phrase, except as otherwise provided under this code. The labor arbiter has original and exclusive jurisdiction over the 6. Okay. There must be a meaning to that accepting phrase. Okay. I'll explain later. Okay. Now, 129, regional director's jurisdiction to adjudicate small money claims, and labor arbiter under 217A6. Question: do the labor arbiter and the regional director share, do they share jurisdiction in the adjudication of money claims? Okay. I'm just warning you because you might have read the old material. Because in June of 1989, okay, June of 1989, in two cases, LM Camus Engineering and Bryad Agro versus De La Serna. De La Serna was a former acting secretary of labor. Okay, De La Serna. The Supreme Court in this first decision ruled that there is shared jurisdiction between the labor arbiter and the regional director. And of course, if you are the counsel for LM Camus Engineering or Bryad Agro, what is your first recourse? Because the Supreme Court here ruled in June of 1989, there is shared jurisdiction. And the reason, so this decision in LM Camus was not based on 129. It was not based on Article 129 of the Labor Code. It was based on an issuance. Executive Order 111, issued December 24, 1986, in the eve of Christmas of the first year after the EDSA revolution. The reason of the Supreme Court in these two cases why they ruled, despite Article 129, which took effect a few months before June, 21 March 1989, based on that decision, the Supreme Court ruled that it is the intention of Executive Order 111 to make available as many labor agencies to the working men. Okay. So a motion for reconsideration was filed on that, with the argument that if all the requisites under Article 129 of the Labor Code are present, that necessarily excludes the labor arbiter from taking cognizance of these small money claims. That is why in November of 1989, the Supreme Court, in a motion for reconsideration filed by LM Camus Engineering and Bryad Agro Development Corporation, ruled that there is no more concurrence of jurisdiction in the adjudication of money claims, provided that all the four requisites under 129 are present. Okay, so let's now outline this bar item. Anyway, you can read Article 129. Okay, so what are the requisites before the regional director? One, this case is brought by any employee or those in the household service. We thought at first that this provision under 129 is only for household helpers. It can also be brought by any employee or those in the household service because of the disjunctive word or. Okay. The money claims arose from employer-employee relationship which no longer exist. Okay. And third, the relationship no longer existing, no reinstatement is sought. So no claim for reinstatement. And lastly, the amount of claim does not exceed 5,000 pesos. All requisites present, as you can clearly define in Article 129, Regional Director excludes the labor arbiter from this case. Regional Director has jurisdiction. Okay, so on that basis, okay. So again, employee is brought by any employee or those in the household service. The money claims arose from employer-employee relationship. The relationship no longer existing, no claim for reinstatement, and the amount of claim does not exceed 5,000 pesos. Note and warning. Republic Act 7730 that we have discussed removed the ceiling of 5,000 based on the Servandos ruling. Republic Act 7730 does not have any effect on the 5,000 is stated in Article 129 of the Labor Code on the jurisdiction of the Regional Director on small money claims. It only affected the ceiling set by the Servandos ruling. It does not refer or it does not affect, it does not reach this 5,000 in Article 129. That should be clear at this point in time. Okay. Okay. So let's now give an example. So Inday A, okay. So you can say Inday A, she is a household helper. Okay. And that is why, so Inday A, that's why a friend of mine, a prosecutor in Quezon City, is about to be dismissed because of a beautiful Inday. She's really beautiful. From a range of 1 to 10, Inday is 10 and a half. Okay. And the only fault of this fiscal against Inday is that, against the wife, is that she admitted that Inday is more beautiful than the wife. Okay. So it's now in limbo, okay, because of Inday. Okay. So Inday brought an action, so she is a household helper. She has money claims, and she is not claiming for reinstatement. No claim for reinstatement, and the amount of claim of Inday is 3,000. This was filed with the regional director. Tell me whether the regional director has jurisdiction over the case of Inday A. Yes, all the requisites are present. Inday is a household helper. She has money claims which arose from employer-employee relationship. The relationship no longer existing. Reinstatement is not sought. So NCR means no claim for reinstatement. And the amount of claim does not exceed 5,000 pesos. Her claim is only 3,000. All requisites present. regional director excludes the labor arbiter from taking cognizance of this case. Okay. But supposing, Inday does not want to go back to her employer anymore, that's why there is no claim for reinstatement. Because every time Inday sees or confronts her handsome employer, she collapses. She will collapse immediately. This time, Inday would like to collapse. Okay, there is a claim for reinstatement. One requisite is missing or wanting. In that case, labor arbiter has jurisdiction. Okay. Inday does not want to collapse, but her claim is 8,000. It's in excess of 5,000. Therefore, labor arbiter has jurisdiction. The claim of Inday is 8,000. At the same time, she wants to collapse. Two requisites are missing or wanting in the example based on Article 129. Of course, if that will be asked in the bar, you will say, with more reason, that the labor arbiter will have jurisdiction over the case of Inday for reason that two or more requisites now. The two requisites are wanting or missing based on Article 129. Therefore, the labor arbiter has jurisdiction. Okay. And if there is no claim for reinstatement and the amount of claim does not exceed 5,000, it is only 3,000. All requisites present, regional director excludes the labor arbiter from these money claims. Okay. Why is it that the labor arbiter is excluded from these money claims? Because of the accepting phrase. Except as otherwise provided under this code, under 6, the labor arbiter has original and exclusive jurisdiction over money claims. Okay. But because of the accepting phrase, it is provided for under 129. All requisites present. That is to the exclusion of the labor arbiter. Okay. It is provided on 129 if all these requisites are present, notwithstanding the fact that after the phrase, except as otherwise provided for under this code, labor arbiter has original and exclusive jurisdiction over 1 up to 6 money claims. But because of 129, it is provided under this code, under 129. That is to the exclusion of the labor arbiter. Okay. So that is the situation there. Okay. And lastly, we will study an example based on 3 Indays. Okay. So Inday A, Inday B, and Inday C, equally beautiful. They file their cases with the regional director. Okay. And the claim of, there is no claim for reinstatement. They're all household helpers. They have money claims which arose from employer-employee relationship that does not exist anymore. No claim for reinstatement for all of them, but they differ in the amount of claims. Okay, Inday A claims 3,000 pesos. Okay, Inday B 7,000. Inday C 8,000. Okay, their employer is Mr. X, and then Mr. X totaled the claims, and this was filed with the regional director. So Mr. X will say 3 plus 7 plus 8. Okay, where is my cell phone with extra accessories? So it's 18,000. Okay. Okay. Now he is contemplating and filing a motion to dismiss on the ground of the jurisdictional amount. So silently in his mind, the labor arbiter has jurisdiction in this case. Is the contemplated ground for the motion to dismiss tenable? Okay. Is it tenable? The answer is no. The totality rule is not applicable in labor cases to determine the jurisdiction either of the labor arbiter or the regional director. But to Article 129 is clear that the jurisdictional amount of either the regional director, is determinative of the aggregate amount of each complainant's claim. So this is the basis of the jurisdictional amount. It's not based on the totality of the amounts of 18,000. Nonetheless, employer X filed a motion to dismiss on jurisdictional grounds, and the basis of the amounts is stated in this joint complaint. Okay. If you are the regional director and you are confronted with this situation, a case filed before you, you have only two choices to do. How do you dispose this motion to this? You either grant the motion to dismiss, you deny the motion to dismiss, but by God, when you will be judges, don't do the third thing. Delay. Okay. This is not your option. Okay? Okay. Okay, how will you dispose of this motion to dismiss filed by employer X? Okay. Insofar as the claim of A, Inday A, is concerned, you as regional director, it was filed before you. I'm now placing you in the shoes of the regional director. That's how the examiner is now placing you in the foot of a labor arbiter, a regional director, secretary of labor, giving you certain facts, and then you decide. Okay, if you are the regional director, how will you dispose of this case? Insofar as the case of Inday is concerned, Inday A, you as regional director will grant the same, will deny the same. What do you mean by denying the motion to dismiss insofar as A is concerned? The regional director is trying to tell the whole world that he has jurisdiction over the case of A because all the requisites are present. A is a household helper. She has money claims which arose from employer-employee relationship, and there is no claim for reinstatement, and her claim is not in excess of 5,000. All the requisites present. The regional director will deny the motion to dismiss insofar as A is concerned, meaning to say that he is telling the whole world that he has jurisdiction over the case of Inday A. But insofar as the cases of Inday's B and C are concerned, you as regional director, you must grant the motion to dismiss. What is the import of a grant of a motion to dismiss of the cases of B? It means to say that the regional director accepts the fact that he has no jurisdiction over the cases of Inday's B and C because of one lacking requisite in its of this money claims of Inday's B and C. The amount of claim exceeds 5,000 pesos. In effect, the regional director is telling the whole world that in the cases of Inday's B and C, it is the labor arbiter who has jurisdiction. He has no jurisdiction. Okay. So that's how the regional director will decide the case. But the regional director was a victim of a poor encoder. Okay. So in the dispositive portion of his decision, prepared by a poor encoder in the office, it reads this way: wherefore, all caps, comma, promises considered. Okay. There is a typographical, and then on the last part, as paid for. It should be as prayed for by God. So get good encoders in the future. Okay. Okay. And also for male lawyers, get good secretaries in the future. Okay. Because there are three kinds of secretaries: the good, better, and best. Okay. So get only the good secretary, not the better and the best. The good secretary will tell to the boss, upon arriving in the office in the morning, will say, "Magandang umaga, sir." Ay, just very courteous. But the better secretary will say, "Sir, umaga na. Okay, so that's the better secretary. And the best secretary cannot utter anymore the word you. Okay, and then said, boss, magana. Okay, so, okay. So, did I not warn you to get only good secretaries? Okay. So, okay. Okay. So, there was a warning, isn't it? Okay. Get only good secretaries. Okay. You know, in the home for the aged in the United States, the old ones are allowed to mix with old people. They are also allowed to do what they want to do, okay? And in this jurisdiction, there is one old Lola, 80 years old. Lola was 82. So Lola asked the grandson, grandson, your Lolo does not even look at me anymore. What will I do? Okay? So the grandson said, Lola, wear a two-piece bikini. Okay? So Lola, that night, Lolo did not even bother to look. Okay? And then Lola again asked, grandson, what will I do? Lola, okay, use an IT. Okay. That night, next night, Lolo did not even bother to look at Lola. Okay. And then third advice, grandson, what will I do? Lola, do not wear anything tonight. Okay. And then Lolo, upon entering, saw Lola. Why did you wear crumpled clothes? Okay. Okay, so okay. So on that basis, Lolo, okay, gave in to Lola, okay, that night. After 2 hours, okay, Lolo was rushed to a hospital, okay? And you know the diagnosis of the doctor? Lolo died of expired milk. Okay. 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 So, and I met one beautiful woman from the Visayas one time. I was in Edsa Sangla. Then directly she was coming to me and kissed me here. Who are you? Sir, I am one of the reviewees before. I passed the bar. Congratulations. Sir, I do not know labor law anymore. Only the jokes. Okay? Okay. Okay. Okay, so before we proceed to Article 130, let's go now to work situations and hours of work, because of the importance of whether certain situations are considered as hours work, hence compensable. So you must know the difference of engaged to wait and waiting to be engaged. There's a difference. Which is considered as hours work, hence compensable. Okay, I'll list it for your purpose. And, okay, number one, there's a difference of waiting to be engaged and engaged to wait, okay, versus engaged to wait, okay. What's the difference? Waiting to be engaged is a situation where the work hours is from 8 a.m. up to 5 p.m., okay? And there's a meal period in between, 12 to 1. Outside of the company premises are 200 people waiting to be tapped to work for the day in this company. Out of this 200 people, 40 were tapped to work for the day. And they waited 2 hours, 1 to waiting to be tapped for this day to work on this company. The 2 hours waiting is in the concept of waiting to be engaged. This is not considered as hours work, hence not compensable. So this is not considered as hours work, therefore this is not compensable. On the other hand, the engaged to wait, the key word here is integral. Waiting is an integral part of the employee's job, and therefore that is considered as hours work, hence compensable. Okay. Another important topic that may be asked in the bar would be the rule on brownouts. Again, the rule on brownouts, number 2. Okay, I'm wondering, while there is no rule on blackout in the labor code, and maybe this is understandable, because blackout is only used in big time bingo, where you block everything. Okay. Okay. So what's the rule on brownouts? First 20 minutes of a brownout is considered as hours work. So first 20 minutes. This is considered as hours work, hence compensable. The next 20 minutes will all depend. Okay, after the first 20 minutes. Okay, after 20 minutes. So here's the rule. If the employer instructs the employees or the workers to be in their workplaces, despite the darkness of the workplace, then that is considered as hours work, hence compensable. And why? Because the employees cannot effectively use their time for their own purpose. There is a direction and instruction by the employer to be in their prescribed workplaces, hence this is considered as hours work, hence compensable. But if after the first 20 minutes, the employees or workers can freely go out of the premises and use this time effectively for their own purpose or benefit, then this is not considered as hours work, hence not compensable. Okay, so the determinative test here is whether or not the employees can freely go out of the premises and use this time effectively for their own purpose or benefit. So that's the rule on brownouts. Okay. How about sleeping time? Okay, sleeping time. This all depends on the nature of the work or the agreement with the employer. For example, at night, during the night shift, employees are expecting 3 trucks to be delivered at 3 hours interval. In between the arrival of the trucks for loading and unloading and loading, employees may work, okay, depending on whether or not this sleep will not interrupt or prejudice the work in that particular company, or by agreement with the employer or tolerance of the employer, that is considered as hours work. Anyway, when the trucks will arrive, somebody will wake them up and then do their job. Okay. Another example here would be a truck driver and a helper negotiating a delivery towards Lucena City. Okay. So driver on the left side, helper on the right side of the truck. The helper can sleep while during the trip, okay? So helper can do that. However, the driver cannot also sleep while driving, okay? So only the helper can do that. Sleeping for the helper would be allowed. How about on-call? What is the rule on a word from the employer near or within the premises of the company? What is the rule? Is this considered as hours work, hence compensable? Okay. Again, the test would be waiting for word from the employer on call. If the employee cannot use his time effectively for his own purpose, he is near or within company premises, then this is considered as hours work, hence compensable. How about in the case of waiting for word from the employer from a cellular phone or from beepers when they were still in use, and from walkie-talkies and other communication devices? Is this considered as hours work, hence compensable? Waiting word. There is no jurisprudence as of yet in this jurisdiction. But in the United States, by a decision of the NLRB in U.S. versus Allen, these are not considered as hours work if one is made to wait for a word or instructions in a cellular or a walkie-talkie. So these are not considered as hours work, hence not compensable. Another situation would be attendance in meetings, lectures, or seminars. Okay. This is an important matter, so please take note of the test. If these three are present, then these are not considered as hours work, hence not compensable. Okay. Attendance in these meetings or lecture is purely voluntary. Purely voluntary on the part of the employee. Number two, it is outside of the work shift of the employee. And third, no productive work is undertaken in that seminar or lecture that inures to the benefit of the employer. Again, I'll repeat the requisites. Attendance in this meeting or lectures or seminars is purely voluntary on the part of the employee. Then it is outside of the work shift of the employee, and no productive work is undertaken that inures to the benefit of the employer. If all these three requisites are present, then this is considered not considered as hours work, and hence not compensable. Not compensable. However, under the first one, if a boss instructs an employee to attend this seminar, even if it is outside of the work shift, even if there is no productive work that inures to the benefit of the employer, the attendance is no longer voluntary. Okay. In the third requisite, it was voluntarily attended by the employee outside of his work shift, but there are work undertaken in that seminar or meeting that inure to the benefit of the employer. The last requisite, not present, then this is considered as hours work, hence compensable. Okay, another item would be preliminary activities. For example, the work shift of the employee is from 8 a.m. to 5 p.m. in the afternoon, and there is a meal period in between, 12 to 1. Okay. 30 minutes before time, there is a bicycle or motorcycle to be cleaned. Okay, outside of the company premises, outside of the company. Okay, so that 30 minutes would be known as preliminary activity. Whether this preliminary activity is considered as hours work or compensable is whether or not, okay, this work shall inure to the benefit of the employer. So this cleaning of the motorcycle, of course, will benefit the employer because these are delivery motorcycles in this fast food chain. Same is true after 5 p.m. If the cleaning of the motorcycles will again, okay, inure to the benefit of the employer, and for sure it is, because this is maintenance on the motorcycles. What's that? So it inures to the benefit preliminary and post-preliminary activities. So after 5, you call these post-preliminary activities. Before time, this is preliminary activities. It all depends whether these activities prior to the work shift of the employee benefits the employer. Benefits the employer. Okay, we go now to the rule on travel. Travel, okay. There are 3 kinds of travel, by the way. There are 3 kinds of travel. The first kind of travel is home to office, office to home. So I will write this because of its importance. According to my appreciation, this is an important kind of travel. So the first kind of travel is office, home to office. Okay, home to office, office to home, and then back to the office and home. Okay. If this is the work shift of the employee, 8 a.m., then this is 5 p.m., meal period. 2 hours is spent by the employee in going to the office. This is not compensable hours work. But if after 5 p.m. again, he goes home and spends 2 hours, this is not compensable, because that is in the concept of home to office, office to home, and back. But if after 5 p.m., he receives instruction from his supervisor to go to a branch office and deliver back the papers to main office, going, he spends 2 hours. Going back, he spends 2 hours. So all these 4 hours will be considered as hours work, hence compensable, okay? But if this employee complied with going to the branch office, but he went directly home because he believes that there are no more personnel in the company, because that would already be 11 p.m. Only the first 2 hours will be compensable. The hours spent in going home is not compensable. Okay. The second kind of travel is travel that is all in a day's work. Travel that is all in a day's work. Okay. This is applicable to messengers, applicable to delivery boys of fast food chains. Travel is an integral part of their job. Therefore, this is considered as hours work, hence compensable. The last kind of travel, okay. I'm waking up myself, okay. That's why I'm shouting. The last kind of travel is travel away from home, okay. Travel, so please take note of this. Travel away from home. Okay. So what's the feature of this travel? That's why it is considered as hours work. So the employee's work shift is from 8 to 5, okay, p.m. And then why is Mr. B not in the office? This travel, sometimes it's an overnight travel away from the office. Why is Mr. B not in the office? He's traveling. So he's not in the office because he's traveling. In other words, the travel by this employee substitutes his being in the office. He's not in the office because he's traveling. But this travel, in order to be compensable, must cut across the workday of the employee. So 24 hours, okay. I did not distinguish as of yet, so that you will appreciate that. What's the difference of a work day and a calendar day? Okay. So here is the work day of the employee compared to a calendar day. It's a 24 hours period, starting from the work shift of the employee, let's say 8 a.m., and ends at a.m. the next day. This is a work day. On the other hand, a calendar day is a 24-hour period which starts from midnight and ends midnight the next day. So in other words, if this travel is being undertaken during the workday of the employee within the 24 hours period, then this is considered as hours work. So this is travel away from home. Okay. So here, midnight, so a workday for the purpose of labor standards is important compared to a calendar day. But rarely will the workday of the employee start at midnight and ends midnight. That's rare. That is where a workday is at the same time a calendar day. But that rarely happens. Okay. So for the purpose of labor standards, it is the workday that matters. Okay, here is employee X who already worked for 8 hours. Okay. And this company has 3 shifts. Then he was made to work on the 3rd shift for 3 hours. Okay. Is this considered as overtime and within the night shift of the employee? The answer is yes. In other words, this is overtime and at the same time night shift. Why? Because it was, the 3 hours was a service rendered within the workday of the employee. Okay. Will your answer be the same if this is the situation? This is the 24 hours period. 8 a.m., this is 8 a.m. the next day, 24 hours. And employee is made to work after 8 a.m. the next day for 3 hours. Is this overtime? The answer is no. What's the difference of this 3 hours in the first example? The 3 hours rendered was within the workday of the employee. For the purpose of labor standards, this is considered as overtime and at the same time night shift. How about this 3 hours after 24 hours? This will just be paid on an hourly rate. This is not overtime because work is now rendered on the first 3 hours of the second workday. Okay, it is different if it is rendered within one workday after completing 8 hours of work is made to within the workday. Okay, so for the purpose of labor standards, workday is important. So a calendar day is a 24-hour period which starts from 12 midnight up to 12 midnight the next day. For 24 years, I've been asking this question. I find no answer at this point in time. And maybe the examiner may not also ask this. The question is midnight night? Okay, so, okay. What's the answer? Okay. Okay, so, don't forget, midnight to midnight, that's a calendar day, a 24-hour period. While a work day is a 24-hour period that normally starts beginning the work shift of the employee and ends at the beginning of the next work day of the shift of the employee. Okay. So here is travel. So you can appreciate this travel. Travel, where is the travel? Oh, it's erased. Okay. So the third kind of travel is travel away from home. Okay. Do you know that this kind of travel is a source of trouble in the home? By the title alone, travel away from home. Okay. So this is travel away from home. And then so that you will not forget the first kind of travel, I'll translate it in Filipino. So this is not considered as Sabbath work. Hence, not compensable. Home to office, bahay opisina. Okay. And then opisina bahay. And then, very good boy. Then bahay opisina. And then opisina bahay aliwan. Okay. So the answer is self-explanatory. Okay. What time is it, lady? What? Huh? 7:45. Okay. What is another few minutes to 0.0001 to get a grade of 72 under the reduced scheme? Okay. Okay. Okay, let's take some labor standards. This is easy listening. Okay. So we are talking about rest day. We are now focusing on Article 91 of the Labor Code, rest day. Okay. And the exceptions to rest day work is Article 91. Okay. So on Article 91, the first question that may be asked, that's why we are analyzing these provisions, who as a general rule determines the rest day of the employee? Okay. Management. And on what basis? Exercise of management prerogative. So general rule, management determines the rest days of the employee. Are there limitations to this? The first limitation would be a would-be hiree who objects to the chosen rest day of the employer or to the work assigned to the employee on the basis of religion, on religious grounds. So he becomes a conscientious objector on the rest days chosen by the employer. Okay, so in this case, how will the compromise be made? The provision is to the effect that employer, if on the basis of religious grounds, employee or would-be employee objects to the choice of the employer, there's a compromise based on the rules. In a month, there are 4 rest days. 2 rest days at the choice of the employer, and 2 other rest days, the choice of the employee based on religious grounds. And the employee concerned must notify the employer of this choice at least 7 days for this rest day chosen by the employee will be affected. What are other limitations to the choice of the employee on rest days? The next limitation, aside from religious grounds, would be a collective bargaining agreement. So if the employer had agreed that these are the definite scheduled rest days for employees working in the company, management cannot vary that without an agreement with the union. Okay, so in that sense, CBA is a limitation to the choice of rest days. Okay, so I'm now placing you in the shoes of an employer. You are now interviewing a would-be employee, and you are now discussing the rest days of that particular employee. Okay, you know, as management, you have the prerogative. Okay, but here is an employee raising religious grounds on your choice of the rest day. He is now objecting to your choice, and then he says, "You know, sir, ma'am, in our religion, our rest days is from Monday to Sunday." Okay. What will you do to this employee? Okay, he is now objecting, and the code that provides for respect of that choice. Okay, will you hire him? Okay, if I were you, you kick this fellow figuratively. Okay, so you will not hire him. Of course, there's an employee who will rest 7 days, and yet you will pay him. Okay, so that's on rest days. Please take note of the exceptions. If you want to get a very concise for your notes on the exceptions, there is one good book on the exceptions to rest days, exceptions to night work prohibition, exceptions to overtime. This is the book of Mr. Ungos. He synthesized these calamities, dexterity of women, okay, and perishable goods. Okay. So that's the book of Mr. Ungos. Okay. So that was the book used 3 years ago in the bar exams. The examiner got it from there. The questions in the examination, book of Mr. Ungos. But that will be a different situation because the book of Mr. Attorney Ungos in Globe Telecom was the examiner in labor. Okay. And so that's it. So that's on the exceptions. Okay. Service charges. There are establishments, and similar to restaurants and other service establishments, where a service charge is collected. Okay. And when a service charge is collected, this will be pulled together, and periodically this will be distributed at the rate of 85% employees, rank and file, and 15% management. The purpose of the share of management of 15% is to answer for losses, to answer for breakages, and if there is an excess and management is mindful, distribute the excess to managerial employees. Okay. Ratio is 15 management, 85 employees. May the employer waive its 15% share so that the employees will get a 100 share of the service charges. Is that still within the standard, and is there a violation in this example? The answer is no. Management can give up the 15 to make it 100 for the employees. But let's reverse it. 10% of the 85% share of the employees is now waived in favor of management to make each share 25, a total of 25. There's a violation here. That's a violation. Okay. Now, another item on service charges would be abolition of service charges. When competition is stiff, for example, in an area in Morato, where there are so many restaurants around, the other restaurant on the other side of the street, okay, remove its, did not collect any more service charges. So a restaurant here, on the other side here, also would like to abolish the service charges. What happens to the service charges previously received by the employees? What is provided for under the law? Employer who intends to abolish the service charges must get the average of 12 months service charges paid to the workers or employees. So 12 months service charge over 12, that is, you arrive at an amount. That amount will be integrated to the salaries or wages of the employees or workers respectively. So that's integrated, okay, if it is abolished. Okay, service incentive leave. When one works continuously for a year, whether broken or unbroken, okay, continuous or broken, provided that the total is 1 year, the employee is entitled to at least 5 days incentive leave pay. Okay. When an employer, by voluntary employer practice, extends to its employees a 15 days vacation leave, as well as a 15-day sick leave, then that is substantial compliance of the 5 days incentive leave provision. There is, however, no law, whether in the code and other social legislation, where the employer is obligated to extend a 15 days vacation leave or 15 days sick leave to its employees. There's no such law. But assuming by employer practice that this is extended to the employees, 15 days vacation, that is deemed compliance of the 5 days incentive leave under the labor code. Okay. There are employers where the practice, there are work effectively, let's say for 9 months, 3 months are non-working months. For example, in the noodles manufacturing industry, 9 months are sunny months, 3 months are rainy months. Depending on the employer practice, service incentive leave may be paid even if they only serve for 9 months. Okay, so that's service incentive leave. And if this service incentive leave is not used, it is commutable to cash. And what is the amount that will be paid to the employee that is being commuted to cash? That his rate, his salary rate at the time of commutation or a conversion to cash. Conversion to cash. So on the concept of meal period, this is a 1 hour, not less than 60 minutes, extended by the duty of the employer to extend to its employees. So this 60 minutes is known as a meal period. Whether the employee eats or not, it is still a meal period. Okay, so, and the concept of shortened meal period, is this allowed in this jurisdiction? The answer is yes, subject to certain conditions. So here is the work shift of the employee from 8 a.m. and ends at 5 p.m. There's a meal period in between of 1 hour. Employees, majority of the employees in this establishment agree to a shortened meal period. So what do? Instead of 1 hour, it's now reduced to only 30 minutes. So meal period will be 30 minutes. So from 5 o'clock, they can now go home at 4:30. So this is the concept of a shortened meal period. And conditions would be agreed normally by the majority of the employees in writing. During the shortened meal period, there should be no hard or strenuous work given to the employees. There should be no diminution of salaries, wages, or other benefits. And the moment that they work after 4:30, under the shortened meal period, that is already considered as overtime. And lastly, the arrangement is merely temporary. Temporary. Okay. Last few items before we go. Successive holiday rule, single holiday rule, and then we go. Okay. Okay, those at the back, can you see the board? Of course you can see the board. It's very big board. Okay. 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 It's a fair question, isn't it? Okay. Okay. The first one is the rest day rule. Okay. Then the next would be the special day rule. Okay, which is a non-working holiday. And then the successive holiday rule. And then April 9, a single day where 2 regular holidays coincide. It's an AK and at the same time a Holy Thursday. Okay? So last few before we call it a night. Okay. So here is a situation where Thursday is the rest day of the employee. He is not supposed to work on this day. But following the rest day is a Friday. So this is a Thursday. Is a regular holiday. And whether the employee is entitled to this regular holiday, which is preceded by his rest day, will all depend on he did on the day previous to his rest day. He was present on a Wednesday, he's entitled. Absent with pay, meaning to say he had a leave application, it was approved, and he therefore was absent on that day, entitled. Simply absent, not entitled. And then absent without pay, meaning to say that he applied for leave application, but it was disapproved, not entitled. The rule on this single day, okay, which is declared as a non-working holiday, is almost the same, depending on, okay, Thursday being a special day. Okay, so same rule, Holy Thursday here, Friday, he is present, entitled. Absent with pay, entitled. Simply absent, not entitled. Absent without pay, not entitled. Okay. We go now to the successive holiday rule. Okay. This are 2 regular holidays in the Christian world. Okay. So you have a Good Friday, then this is also a Holy Thursday. Okay. I do not know what is the day before this Holy Thursday and Good Friday. This is a day where people will do what they cannot do in these 2 regular holidays. Okay. So whether the employee is entitled to the successive holidays depends on what he did on a Wednesday prior to these 2 successive holidays. He was present, entitled. Absent with pay, entitled. Absent without pay, not entitled, okay, to both. Absent with pay, without pay, not entitled. But if you work on Holy Thursday, he is entitled to the regular holiday pay next on a Friday. So he was absent without pay on a Wednesday, not entitled to the regular holiday pay for Holy Thursday. But if you work on this day, he's entitled to the Friday regular holiday pay. And lastly, in the case of a single holiday, a single day where two regular holidays coincide, okay? This was a bar item about 3 years ago, and this was hotly contested by the Ateneo group and the UP group, okay? So what was the question? So here is the framework by this April 9, okay? A single day where two regular holidays. It is a Holy Thursday. It actually happened in an actual work situation, and it is at the same time an AK. What's AK? Araw ng Kagitingan. Filipinos and the Americans were so brave that they surrendered to the Japanese. Okay, that's why this is Kagitingan, not Karuwagan. Okay, that's why it's a holiday. Okay. And at the same time, I'm reminded by the inventor of AK-47, the cause of many deaths in the world. This is the assault rifle of rebels all over the world, in Congo, in everywhere, including Mindanao. This is Mr. Anton Kalashnikov. Okay. So here, the previous debate of labor and management. Okay. Labor insisted that if this is not work, it is entitled to 200%. And if work, but how about management was of the position that if not work, employees is only entitled to 100%. Okay. On this basis, an explanatory bulletin was put out, issued by the DOL, adopting the position of labor, that if on this day the employee does not work, the employee is entitled to 200%. Okay. What was the reason given by the DOL why they adopted the position of labor? To adopt the position of management, okay, that it is only 100% given to the employees on this day, that would in effect reducing the number of regular holidays under Executive Order 203. Okay, so 200%. Then came the question 3 years ago. Supposing the employees work on this day, okay, the Ateneo group, based on the rules, just multiplied 200%, if not work, times 2, because there are two regular holidays, 400. Basis, percent, implementing rules. The UP group insisted on the explanatory bulletin, that clearly in the explanatory bulletin, if this is work, it is only 300%. Unknowing to all, okay, I was there, that there was already a case in the early 2000 decided by the Supreme Court in Asian Transmission Corporation, where if work, the employees are entitled to 400%, thereby superseding, okay, the 300% set by the explanatory bulletin by the Department of Labor. So this is 200, 300, 400% if work, if unworked, 200%. Ateneo group was right to some extent, okay, because of the amount of percentage arrived at 400%. Okay. So one last thing would be 1:30 and 1:31, 2 minutes. Okay, and we go. Night work prohibition. So your keyword here is, as a general rule, night work is prohibited. Okay. So your keyword here is ICA. Okay, remember? The Immaculate Conception Academy of... Okay. For industrial undertaking, there's a prohibition for women to work from 10 p.m. up to 6 a.m. the next day. In commercial or non-industrial undertaking, 12 midnight up to 6 a.m. same day. Okay, and then in agricultural undertaking, there must be rest given to the woman employee for non-consecutive hours. Otherwise, this woman cannot be allowed to plow the field in the darkness of the night in agricultural undertaking. Okay, so for agricultural undertaking, a woman should be given 9 hours of rest within the workday so that she may be allowed to work at night. And Article 131, exceptions to night work. Okay. Exceptions to night work. If the prohibition for women to work at night is absolute and applies to all, then this is a gloomy world. Okay. And you will no longer see nightclubs at night. It's a gloomy night. But you know, businessmen will still be innovative. They will be creative. You will see the proliferation of day clubs everywhere. Okay. Okay. So, with that note, what time is it? Are we missing some time yet? Okay. We call it a day, and then I'll meet you at exactly 1 o'clock to 1:15 tomorrow, whichever comes first. Okay. 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 A second silent prayer for graces of the Almighty and Allah. Okay.